Any mention? Daily list, item number 1.
Please, Lordship. This matter, as per the last order, I have filed a rejoinder, Lordship. However, Lordship, I pray for to intelligence this matter, to argue this matter on some time, Lordship.
You want to argue matter today? Argue.
No, I'm just praying time to argue.
Why?
I pray because
They made some technical objections to
yes,
your
Lordship, only
legitimacy
yes.
of your this petition.
Their main contention, their objection is that their only contention is that they are saying that I have published in the newspaper regarding the PIL. But it is not. I have, in my affidavit, I have clearly, categorically stated that I have filed this PIL only when there is a specific, there is a depot 10. I'm not extending my the PIL. My limited of this PIL is they have enclosed in the document that there is a depot 10 in Zadictum. That my contention is there is no code existing or dam in that particular depot 10 number Zadictum which is in existence. My contention is there is no core existence in that particular place. Secondly, Lordship, in their affidavit they say that I have filed this affidavit only for publicity. Now, in that regard, Your Lordship, in their annexure, in the affidavit where they have annexures also, nothing has been stated. I have pursued.
No, one thing, basically, first thing, Mr. Samay understands is that when you want to argue the matter, is that they are questioning your bona fides. Okay.
Lordship.
Who is a public interest petitioner? That's the number one. They are questioning your bona fides. Okay. Number two is the questioning the manner which you've gone about it, obtaining RTI, publishing the paper even before the PIL was filed. Yes. Number three is technical objections they've raised with regard to the maintainability, whether it comes within the meaning of PIL and whether you have complied with the rules, PIL rules of the High Court. Those are three things.
Yes.
So firstly, when you argue, you prove your bona fides. Who are you? And how are you interested? And how you're not personally interested. You get it?
Yes,
the number two is that your actions prior to filing the PIL, whether it is not in furtherance of some other hidden agenda that you have.
Yes,
that's the thing. Because you already published in the papers that I'm going to file a PIL and this is happening, that is happening.
Yes,
correct.
Yes, that
so
is.
You already in a manner have already stirred up parallel kind of situation.
No, actually, that I will satisfy Lordship at the time of hearing. That's why because they make us.
We hope you will be able to satisfy.
Yes, Lordship.
But you prove your bona fides.
Lordship.
Yes, rejoinder has been filed to the affidavit challenging the maintainability of the instant public interest, instant PIL. Mr. P.T. Sharma, please have been given some accommodation and that another date be fixed for admission hearing of the matter. Not any objection?
Oh my God.
Then the
No.
not object to the Advocate General. Listed when?
Any convenient date, Lordship.
Yes.
What plus, Lordship?
Item number 2.
May please, sir, suo motu PIL, my lord.
One second. Let the file come. Yes.
Lordship, we have filed the status report in terms of your Lordship's last order, dated 19th December, my lord.
Yes.
And we have also transferred the officer from the concerned district to the other district, my lord. And Justice Kataki has monitored all this development on 2nd February, my lord. He held a meeting on 2nd February 2024. And if I can take your Lordship to the latest position, my lord, in paragraph 4, my lord, of my status report.
That is page?
Page 3, my lord.
Okay. Yes.
So the first issue is with regard to transportation of coal which have been inventorized, my lord. So first district is South Garo Hill district, my lord. Transportation of re-inventorized coal from pit head to the designated depot is almost complete in South Garo Hills. Out of 62,752 metric ton, only 3,580 metric is left to be transported, which transit pass have already been issued, transportation of which will be completed within 2 weeks' time as per direction of Justice Kataki on in meeting so and so. So only balance amount left outside the legal coal inventorized coal in South Garo Hill district is 3,548, and that will be completed within 2 weeks' time, Milord. This with regard to South Garo Hill. West Khasi Hill district, Mr. Milord. In respect of West Khasi Hill, Mr. Milord, inventorized coal is 53,070 metric ton. Quantity of 18,993 metric ton was left over from the last auction conducted on 3rd November 2023. Transit pass have already been issued to coal owners for remaining quantities. Sufficient space is now available in depot. The completion of transportation will be completed within a period of 2 weeks, Milord. Yeah. Southwest Khasi Hill district, Milord, the total inventorized coal is 2,89,662 ton, Milord, out of which 90,551 is yet to be issued due to non-available space of depot. However, as per discussion held on so and so, a new depot capacity of 1,50,000 metric ton has been notified, and consent to establish and consent to operate has been granted. Process of issuance of transit plans and transportation of remaining invoice work to be completed by end of February 2024. So the deadline has been given that we have to complete it by 2024, Milord, with regard to balance coal of 90,552 metric ton. Milord, the East Jantia Hill, where we have got the quantity of 10,04,000 re-inventorized coal, out of which 8,54,000 has been issued and transported from pithead to CIL code designated depot. So 8,54,000 has already been transported, Milord. Our balance is 1,50,000 transit pass are yet to be issued despite availability of space in the depot. Reason being that coal owners are not approaching the office of Deputy Commissioner for applying for transit pass despite public notice and instant one issued time to time. As per decision taken on 2nd February 2004, chairmanship of Justice Kataki, it is so and so, the committee has decided that to recommend to the Honorable High Court to issue ultimatum to coal owners to transport the coal from pithead to depot within a month, after which their coal will be seized and taken into custody by state government, and auction of as per procedure laid down, and funds collected from the state go to state revenue. No fund will be credited to coal owner, and a prayer would be made to the committee to grant some time to 30 to 40 complete the transportation, Milord. So 1,50,000 we are having a problem in East Jantia Hill, Milord. Then there is a second head, Milord. They are illegal coals and FIRs which are registered time to time, and they are also seized and they are auctioned as per the order of judicial magistrate, Milord. So that you also will see Southwest Khasi Hill district. We have seized 34 metric ton and in the auction because the order has to come from the concerned court, Milord. We are taking steps in this direction. West Khasi Hill district, Milord. Total quantity seized has been completed. Necessary order for district lifting has been issued. Quantity of and transportation after the necessary payment made and transportation of challan. So these are the processes. Milord, time to time, whenever we find illegal coal or detect illegal coal, the cases are registered under MMDR, Mining and Mineral Development and Regulation Act, Milord, and we take steps. This process is ongoing process which keeps on. We keep taking these steps, Milord. So this we have been going and we are taking orders from the court, Milord. So and therefore everything, Milord, is now getting monitored. Now we are at the fag end. We are at the fag end of transportation and everything, and except for East Jantia Hill, Milord, we will be able to complete the transportation of coal from all other districts by the end of this month to the designated depot of Coal India, and Coal India thereafter will auction the coal, Milord, through its agency. MFDC is the agency, Milord. So therefore any coal found, Milord, because now we have got inventorized coal, we know the designated depot. Any coal found outside this area, marked area, they are illegal. As per Supreme Court direction also, FIRs are being registered and the coal is being seized. No payment is being made to anyone. The money is going to the coffers of the state government, Milord. So all these steps are being taken, Milord. Your Lordship may monitor this whole PIL after in the first week of March, so that the coal will get transported
One
in
thing,
other districts.
Mr. RK General, the thing is
Yes,
that
sir.
you have noted in page 6, the same paragraph 4, I think, of your
Yes.
page 6, that the committee decided to recommend to Noble High Court to issue ultimatum to the coal owners to transport the
Yes,
coal
sir.
to the pit heads to the depots within a month's time, after which the
Yes,
coal will be
sir.
ceased.
Yes.
Now,
Yes, sir.
do you mean to say that these owners are refusing to transport the
Yes,
coal
sir.
to the designated coal
Yes, sir.
dumps? Why?
Yes, sir. Because we have issued public notices also, because the list is there when they came and claimed that these are the coal mined by them up to July 2019 in terms of Supreme Court order.
Fine. I mean,
So in terms of that,
then that means you
so,
should take action. You should seize that coal if they are refusing. That means they are trying
yes,
to
sir.
keep it there
But
so that they can take more
because
coal and dump it together with the
yes,
inventorized coal.
that is 1,50,000 metric ton is so if your lordship give me because the issue is that the in terms of the court order we Supreme Court order, my lord, the what Supreme Court has directed that we have to auction we have to transit the entire coal to the coal depot of Coal India, my lord. From Coal India, thereafter Coal India will auction it. If your lordship permit us to seize it,
Yes.
despite sufficient opportunity and given to the four owners, if they are not coming, my lord, kindly give me 2 weeks in 2 weeks or 3 weeks
now
time.
we
Whatever.
are on today is the 9th, correct? Yes. And
Yes,
if
sir.
as per the committee that the entire coal should be in the depots and auction by 29 February, so we'll keep 29 February as a cutoff date, after which
Yes, sir.
any coal that's inventorized outside where they are transporting to the designated
Yes,
depots
sir.
should be seized and auctioned. And the seizure also
Yes.
will be that the owners will not get any proceeds from there. They'll go as
Yes, sir.
revenue to the government plus that environment restoration
Yes, sir.
fund.
I bow down. I bow down.
That is the thing.
We'll do. Your lordship may
Because
issue
you
this
see,
direction so that.
there were some newspaper reports also regarding this illegal mining still going
Yes,
in these
sir.
areas.
Yes.
The thing is that they don't
Yes,
want
sir.
to shift the inventorized coal, because once it's done and the entire lots auction, that means the slate becomes clean, right?
Yes,
So it
sir.
becomes clean,
Yes, sir.
and even the committee, I think, has asked for drone survey after the auction, or when all the coal come to depots. So after that, we start on a fresh
Yes, sir.
slate. That is the thing. So
Yes,
any
sir.
coal that comes
Yes.
out after that is would have been illegally extracted.
Yes, Lord. Yes, Lord. So if that kind of direction is passed, my lord, that if the coal found after 29 February
Yes.
outside, they can be seized and they can be auctioned off, and the coal owner will not get a single penny, and money will go to the state revenue and MEPRF fund, my lord.
Then what
My
about
lordship,
other compliances?
we are doing the other compliances, my lord. The Don Bosco is getting investigated, my lord. The matter is getting investigated. Then your lordship will see other compliances is existing they are being monitored by Justice Kataki regarding existing mine pit, my lord. State of scientific mine, your lordship will see at page 12, paragraph 2.
Yes.
We have received 17 applications obtained and licenses. Geological report of respect of have been obtained. In 4 have been submitted to mining plan for consideration of approval, and 4 mining plan has also been approved, my lord.
Okay.
And they have submitted for environmental clearance to the state and central government. So it is 4 mining may commence very soon, because they have now environmental clearance is only issue pending, my lord. Environmental clearance to the state government and central government. So in case of 4 legal mining will start in Meghalaya, my lord.
Okay.
Very
Now,
soon.
another thing is that 20th interim report has been filed. I think day before yesterday, and where is copies been
So
received.
that a copy may be furnished to me, my lord.
Yes.
State. A copy may be furnished to the state.
Yes. An updated status report and reply to the 19th interim report of Honorable Mr. Justice retired BP Katiki has been filed by the state of Meghalaya. In the said status report, the said status report has dealt with the matter regarding transportation of remaining inventorized coal from the pit head to the Coal India Limited designated depots. It has been indicated in the report itself with regard to the amounts of coal in the various districts which are yet to be transported and transit passes issued. In the other districts, they have no objection. They all transporting, except East
Yes.
Hills, I mean.
East Hills, my lord.
Except East Hills, yes.
Yes.
In respect of the other districts, namely South Karnal district, West Khasi Hills, Southwest Khasi Hills, it appears that the process of issuance of transit passes and transportation of the entire remaining re-inventoried coal from the pit heads to the depot will be completed by the end of February 2024. A point of concern, however, is with regard to the status report with regard to East Jayanta Hills district, wherein it has been indicated that out of a total quantity of 10,04,587.502 metric tons of inventoried coal, approximately of which over 8.54 lakh MT for coal transit passes have been issued for transportation from pit heads to the CIL designated depots. For the remaining quantity of approximately 1.5 lakh metric tons, transit passes are yet to be issued in spite of the availability of space in the depots in the district, for the reason that the coal owners are not approaching the Office of Deputy Commissioner for applying for the transit passes, in spite of... You already issued public notices also, no?
Yes, I have issued public notices.
In spite of public notices which had been issued, stop. In this view, the matter, the remaining coal, that is 1.5 metric tons, should be transported to Desert Depot within this month itself, failing which the coal will be seized and taken into custody by the state government and auctioned off.
Auctioned off by Coal India, my lord, because that is the power.
And auctioned off by Coal India Limited.
As per the existing procedure, because
within
they have
one
laid down
month,
the procedure.
within 1 month thereafter, by the CIL. The sale proceeds of the such seized coal shall be entirely deposited in a government fund after payment to the Coal India Limited for the auction and to the MEPRF, that is, the full nomenclature, Environmental Preservation Restoration Fund. So up to this effect, public notice should also be published by the respondent states, by the concerned authority, and information widely circulated. Stop. With regard to the, it has been also set out in the status report that other compliances are underway with regard to the status of, with regard to scientific coal mining in the state, the closure of existing coal mine pits, the setting up of integrated check gates with mineral tracking, and as also the status of the audit on the source of coal used in the coke oven plants, stroke ferro alloy plants, and cement plants. Stop. Next paragraph. A 20th interim report, next paragraph, has also been filed by the committee, or by Justice B.P. Kartuki retired, wherein certain recommendations and observations have been made. A copy of the same to be made available from a registry to all concerned parties appearing in the matter. Stop. When should we list it? We list this matter in the first week of March.
Yes, sir.
First week of March. Coal India? Anything to say, Mr. Amit?
Second week of March. After 12.
This is matter on 12th March. 12th March is?
After 12.
After 12. 13th March.
No, 13.
This is a matter on 10th March.
14th or 15th?
14th March, yes. Yes. A status report be also filed with regard to the observations made in the 20th interim report. Yes. And one thing, Mr. Advocate General, you just, we're not recording it, you alert authorities regarding news reports that are there. That, you know, if those further reports, the next date will be compelled to take.
We have taken note of that, my lord. We have taken note, and we are also
call a deputy commissioner here. Yes.
Item number 3.
May I please, Your Lordship? Your Lordship, in this matter, I will let this matter be taken up next week, Your Lordship.
After?
Next week, Your Lordship.
Why?
Because the connecting council who is arguing this matter is our station, Your
Where
Lordship.
is he? He's on his legs out of station?
He's our station, Your Lordship.
Out station?
Yes, Your Lordship.
Mr. Day?
Yes, Your Lordship.
Mr. Deb also?
Yes, Your Lordship.
Who's conducting, Deb or Day?
Day, Your Lordship.
Malad, in item number 3, I am appearing for the respondent number 3, Malad, State of Assembly.
Yes.
The petitioners, they have filed an affidavit, Malad, the last order reflects. Malad, I prefer a copy, Malad.
You have supplied copies to the parties?
We supply the copy.
No, Malad, I have not. No, I have not
Yes,
received.
okay, we'll
In fact, in the morning also I have
Raji,
contacted.
on behalf of the conducting council, Mr. SD has prayed that some accommodation be given and the matter be taken up next week. Mr. D. Nath, next one, Mr. D. Nath has submitted that the copy of the affidavit filed by the petitioner has been received. Accordingly, you supply copies. Accordingly, council is directed to supply copies to all the respondents. This is a matter after, on 12. On 12, on 14 March. We'll list together these matters.
Lodge.
Item
obliged,
number,
Lord.
item number 4.
My Lord, I am appearing for petitioner in this matter, Your Lordship. My Lord, in this matter relates to, my Lord, running of coke plants, my Lord.
Yes.
I think, my Lord, most of the illegal running coke plants have been demolished.
Yes.
So my Advocate General also, my Lord, on the last occasion apprised that 37 coke plants have been demolished by state government. So I think, my Lord, this matter, nothing survive in this matter, my Lord, so far as this matter is concerned. Subject to what my learned friend will say.
Yes, who's
My lord,
appearing?
I don't know.
Yes.
I am appearing to the state, my lord. We have taken action in this matter, my lord, and we have something to say about the locus of the PIL petitioner, but there is another PIL file. There,
I will
my lord,
apply
Yes, yes.
that. I will apply in that.
Yes, yes. So what should we do? We close this one? Because as per the 20 internal
This your
reports,
lordship
I've
may
seen
close.
that. We'll close it?
Your lordship may close this PIL.
Yes, sir. Now, item number
4, your
yes,
lordship.
yes,
4, my lord.
The petitioner, Mr. A. Goyal, the council petitioner submits that due to the action that's since been taken with regard to closure of the illegal coke oven plants, nothing survives the consideration. In this instant, PIL prays that the matter be closed. Let Advocate General, other respondents have no objection. Stop. Accordingly, the matter stands closed. The matter stands closed, yes. And disposed of, yes.
Item number 5.
Again, my lord, this is coke. Same matter, my lord.
Now, who's appearing for the petitioner here? Who's appearing for the petitioner here? No one. No one.
Last time also probably no one appeared, my lord. And if your lords will see the description,
Anyway,
again
this matter also being related to the operation of illegal coke oven plants, in view of the compliances, in view of the action taken by the authorities in shutting down the illegal coke oven plant, does not survive for consideration and is accordingly closed and disposed of.
Item number 6.
Yes, my lords, I am appearing from behalf of.
One second. Last time nobody appeared, yes? Who's appearing here? Sri Christian.
My lords, I am appearing on the behalf of petitioners, my lord.
Yes. Yes.
My lords, we have filed the reply, my lords, along with the GST report, my lords. We have taken in the RTI, my lords.
Where's
the
the
state
reply?
has not filed any reply, my lords, after that.
The last reply was filed in 20th of July.
yes, my lord.
Yes, my lords.
By who's this George? Who's appeared to respond number 11? Where is it? No, he said that after the reply has been filed, what do you want to do this matter today? What is the concern?
Your lordship, kindly see the prayer. Matter can be closed, my lord. Kindly see, Justice Kataki is monitoring, and they are all interloper. Kindly see the prayer, my lord. Page 14. They are all having vested interest, and they are filing this privilege PIL, my lord. They are, page 14, my lord. Direction has already been passed by lordship in suo motu call time to time. Written in the nature of mandamus, shall not directing the respondent to seize and stop export of illegally mined coal from the state of Meghalaya. Coal originating from outside state of Meghalaya. Directing respondent to constitute independent committee, repute person to call an inquiry in Bangladesh, my lord. And so these matters are under the aegis of Justice BP Kataki, my lord. The lordship has been seized of all these matters suo motu PIL, my lord. And if your lordship will see the bona fide of these persons, my lord, they have all business rivalries. Your lordship kindly see paragraph 2 at page 5. He is 22 years old and is working in large public interest of destruction of environment. He is a public spirited citizen with keen interest on environmental laws, my lord.
Oh, Mr. Petitioner, what do you have to say? You want to pursue this PIL?
My lords, in this, my lords, the respondent number 11 alleges that the trucks, which the number has been given, my lords, in their reply, the numbers of the trucks, my lords, and the, my lords, the coal which has been came from Jharkhand, my lords. But my lord, when we filed the reply with the RTI given by the GST department, my lord, the trucks are roaming in the periphery of the Jharkhand, my lord. They have not come to Meghalaya any time, at any point of time, my lord.
Yes.
And my lord, the state has not been taken any action till date. And my lord, we can also give the coordinates to the state that the coal of the respondent number 11 has been hidden in South Garo Hills. We have.
So if my friend is having all these details, if my friend is having all these details, my lord, nothing prevented him to approach Justice Kataki or state government. They are all trying to make a political case and also a case of business rivalry. They can give us the report, we will act on that report. But they are saying that they have the coordinates and coordinates. Kindly let me show single representation by them. Single representation.
Mr. Advocate General, what does he have to say? You finish your submission, Mr. Sharma. What do you have to say? Apart from the truck numbers or discrepancy, and what else do you have to say? See, the thing is that now the committee is there. If you have any grievance, the committee is fairly looking at all the the complaints and grievances that any party has with regard to the illegal transportation or use in coke oven plants, or that kind of thing. So, what did this ever come before the committee?
No, my lord. No, my lord. There is nothing. Not a single government.
Okay,
they did not go to the committee.
We'll listen next date, 14th. You take whatever required step before that. We'll see. Yes, this will matter on 14th.
Yes, my lord.
You take a call.
Highly obliged, my lord.
Since you don't seem prepared, so what to do? Yes.
Item 7.
Yes.
Item 7 also similar prayer may be given your
This
lordship.
is on the prayer and Raji, this one's 14 to get the other matters.
Much obliged, lordship.
Item 8.
May it please your lordship, I am appearing for the petitioner, my lord. Yesterday I have filed rejoinder to the affidavit filed by state, your lordship.
Wait 1 second.
It was filed yesterday, my lord, to the affidavit filed by state.
Mr. Advocate, you seen the reply, rejoinder file? Yes?
Unmute.
Sorry, I have seen, my lord. I have seen, and I am ready to argue, my lord.
Yes.
I can argue, and I am ready to argue this matter.
May I start, my lord?
Yes.
My lord, basically, state has raised two questions: my bona fideness, my locus, my lord. And so far as merit is concerned, my lord, I think my lord, state is also aware that something is wrong there. My lord, so far as my lord, the petition is concerned, my lord, it is relying on a complaint given to state on 10th of July 2023.
On?
My lord, dates are very important, your lord. 10th July 2023.
Your lordship's permission,
Yes.
With your Lordship's permission.
Yes, Mr.
My Lord,
Mishra.
I have raised a preliminary issue regarding maintainability of the PIL.
Yes.
And the only ground on which I am banking on is that this PIL is not in accordance with the High Court of Meghalaya PIL rules 2013. So your Lordship may take up the preliminary issue first.
Okay, yes.
That's my request, my Lord, before your Lordship go into the merit of the
Right.
matter.
Start, Mr. Mishra, yes.
My Lord, what I am saying, Your Lordship, so far as state affidavit is concerned, Your Lordship.
Yes. No, but you see,
So
Mr. Mishra's submissions are to be taken into consideration also because he has preliminary objections to maintainability of your.
That's why I'm addressing to that, Your Lordship.
They have to read it first. Then you have to answer to the objections. Yes, please start, Mr. Mishra.
And I have also similar objection, my lord. After
Similar
Mr.
objection
Mishra,
raised by state, my lord. So,
I have also similar. After Mr. Mishra's objection, my lord, I will also add 2-3 lines, my lord. And then Mr. Goel can reply, my lord, thereafter.
Respondent number 7 is the beneficiary of that, my lord. The state has also raised same objection, Your Lordship. And my lord, accordingly, I have filed my rejoinder, meeting up that objection, my lord. As my lord learned senior, my learned senior is appearing, my lord. When, my lord, you have nothing to say on merit, focus on locus. This is the, my lord, training given by.
You can argue this after me. You can argue this after me. Let me just please. I will not take.
Yes,
much
Mr.
time.
Mishra, just please your case.
My lord, I have filed a compilation for your lordship's convenience. I have given, my lord, copies to be given to everybody. It's a compilation.
I have not received
It's
this.
compilation of all the available material which are there on record.
That I have
and
not
mainly PIL and the decisions. So there is nothing
We do one
new
thing then,
here.
Mr. Mishra, you give a copy to Mr. Goel. He's expressing.
I have already, my lord, it will be handed over to his junior if he is there. I have given for Advocate General also, everyone.
But I have not received. Subject
Mr.
to.
Andrews.
Mr. Goel, you don't have a local counsel here, Mr. Goel?
Yes, my lord.
Where's the local counsel?
Miss Purnima Rai is there, Your Lordship.
Who is that, Mr.
Mr. Andrew will hand over, my lord. It's the compilation, there is nothing new.
Other copies he has received, Your Lordship.
Then we'll post it on
This is
14th.
not filed as
Please circulate
anything.
the
This is
copies.
for the convenience of the court.
Yes. You circulate the
Because
copies.
I
We'll
can
have it on
from the
14th.
room.
Then this matter for hearing on maintainability of the instant PIL on 14th. Compilation as supplied by the respondent number 7 to be circulated to all the necessary parties.
Just been handed over.
Deeply.
And at 14 we'll take it up, Mr. Goel. Is the thing.
My lord.
Yes.
Deeply.
Any mention?
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 15 of the main list. Your Lordship, the conducting counsel, Mr. K.C.
One second. That's 15.
15, Your Lordship. The conducting counsel is on sanction leave, Your Lordship.
15 is Enul Star Marwin.
Yes, Your Lordship.
15.
Yes, Your Lordship.
Your Lordship, 16 to 29 are connected matters.
16 to 29.
Yes, Lordship.
15 is connected to all of them.
Yes,
Yes,
Lordship.
Your Lordship.
Then 15 is connected to 16 up to 29.
Up to 29, Your Lordship.
Then how will you adjourn this matters then? You ready?
No, from our side too, we are ready.
You ready from your side?
Lordship,
Your Lordship, as per the last time that we, the last hearing, Your Lordship, they were supposed to bring about a confirmation regarding, they had sought some time for instructions.
You ready with the instructions today?
No,
Your Lordship,
my Lord, this one of my colleagues was not here. It is Abraham.
Who was not here?
Abraham.
Where's Abraham?
Your Lordship, the respondents have to produce the letters.
Let's see the last order. Oh yes. It's a serious matter. Yes. KP Bharatsaji, where is he?
Somewhere maybe. I have seen. Maybe in the other court.
See, you seen this last order? Order dated 11th of December. You kindly read it. We'll fix a short date, you produce those letters, yes.
Yes, my Lord.
Okay,
In the next date, we will produce
Yes,
it.
a praise been made for adjournment by MSD Maori on behalf of Mr. Kesuch Gautam. Stop. This matter is connected to item 15 from item 16 to 29 in today's list. Stop. As per the last order, the state respondents were to produce relevant letters as recorded in the order dated 11/12/2023. Let's up to 2 weeks.
Yes, much.
Set instructions to be produced on next date is. And from 16 to think this. Oh, you're right, same one.
May it please Your Lordship. Lordship, I beg to mention item number 36, Lordship. Lordship.
36.
What's the matter about?
Mining 100 hectare, Your
Why?
Lordship.
I'm not feeling well, Lordship.
May have it in short that, Your Lordship.
Where's Mr. Manta?
He's for the petitioner, Lordship.
Oh, you argue briefly.
Yes, it is not.
Okay. Just after 2 weeks, yes.
Much obliged,
Prayer of
Lordship.
the respondent, senior government advocate, yes.
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 Much obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 35, Your Lordship. I am prepared that this matter be taken after 2 weeks, Your Lordship.
Why? You ready with the matter today?
The conducting counsel is on sanction leave, Your Lordship.
But you've been arguing the other matters when connected counsel is not here also.
Your Lordship, I am not prepared today, sir.
Okay, 2 weeks.
Much obliged, Your Lordship.
Much obliged, Lordship.
May it please Your Lordship. Lordship, I beg to mention item 38.
30?
April, this matter may be taken over. 38. 38, Your Lordship.
Where's Mr. Chakravarti? He's not here.
He's not here, Your Lordship. I pray for 2 weeks, Your Lordship.
2 weeks.
Highly obliged.
Obliged.
Request of counsel for the petitioner, yes.
May please, Your Lordship, I beg to mention item number 37 from the main list.
37. You're appealing for whom?
Respondent number 4, Your Lordship.
For the petitioner, no objection.
Yeah, objection.
No objection.
Why? No objection like this. And you are appealing for the counsel? Yes, on the prayer of Pursuance of number 4. This is matter after 2 weeks. Yes.
May I please, Your Lordship? Lord, I beg to mention item number 39. Actually, my Lord, on 13/12/2023, the state has filed an additional affidavit. So we want to file a reply to the affidavit and also one application because there's certain development in this matter, my Lord, which happened on 24th December 2023. If it may
Regarding that security in the village?
Yes, my Lord.
That person who ran to the jungle or something?
No, that alleged witchcraft to that person. And there was an attempt also by
that
some...
fellow we saw in the dream?
Yes, my Lord. And there was an attempt also to set up the house of the petitioner on fire on 24 December, my Lord.
Show the file. What affidavit did you file last time?
Your Lordship, Ms. Z.E. Nong Kendri had filed an affidavit, Your Lordship, bringing on record the FIRs, Your Lordship.
They have not only the FIR.
Okay, this is matter after 1 week to enable Mr. L. Chongwan to file the reply to the government affidavit and also to bring on record further developments in the matter. Yes.
My Lord. Obliged.
Obliged, Your Lordship.
Please, Your Lordship, I shall be able to seek your permission for testing the matter on Monday, Your Lordship.
What matter?
Regarding the election.
Chanda's matter?
No, Lordship. It's a private matter. Regarding the election to the post of Sardar, Lordship.
Sardar of?
Nongjari Ilaka, Lordship. Because the...
It's only pending matter?
No, Lordship. It's a fresh matter. Some urgency is there because... Obliged.
Lordship, I'd like to mention item 33, Your Lordship, of the hearing list. 33.
33? Who's appearing other side?
So, Lordship, even the
Ms.
conducting...
Yatham, huh? Yatham. You have objection?
No, Your Lordship.
What's this matter about? That
Lordship,
escrow
is that
account?
escrow account.
These matters are just hanging.
Lordship, it can be on request of the joint parties.
Okay, request of the parties is matter for 2 weeks, yes. Yes.
Highly obliged.
Supplementary list, item number 1.
Yes, Mr.
May please, Lordship. This matter, Your Lordship, this petitioner is the legal wife of the private respondent number 3. The private respondent number 3 was working as a Kalasi in the Meghalaya survey department, Your Lordship. Now, that private respondent number 3 has decided his wife, the petitioner, for some time, and he was getting this maintenance allowance. However, the private respondent number 3 now he has been retired in the month of December 2023. Now the petitioner have sought, requested the department also the private respondent at least to share some
maintenance under 125 earlier on.
Yes, we have. Then now we are asking only at least some benefit of 50%. Lordship.
How are you asking from this court?
No, Lordship. The department we have approached numerous representation has been made to the department earlier prior to the retirement and after retirement also saying that at least 50% because I am having 3 children. At least having 3 children. Now he is having a relationship with the private respondent number 4 without any legal merit. But I am not claiming for entire amount, but at least to share some personal benefit.
You already have maintenance case was going on.
No, maintenance case is over. After the retirement, I am not getting any more maintenance, Lordship.
Well, it is. As pointed out by my Lord, Lordship, under 125 CRPC is already receiving the interim maintenance.
Now I am not receiving anymore because after retirement.
Before the same court,
yes.
No, I'm already not receiving the retirement
Why don't you go to
benefit.
same court? No, just put on a new file if you retire.
It is since long back I have not received
only
it
way
because
back to court after retired.
Yes, you see, since only in the month after retirement I have approached the department, Lordship.
No, did you approach the court or not? Which give the maintenance order.
In the court, in the court, actually, I have not approached the department. But only that only my lord. I just see the order. This is since from 2007. From 2007, the petitioner that maintenance has not been only for some months I paid. After that, they have stopped me.
You mean to say that he had applied for maintenance and in 2007 some money was given to you, after that no money is given?
Not.
Then how can we maintain this repetition?
But at least
they're stretching. Like you're stretching the limits of jurisdiction to non-breaking point.
But this department is involved at least.
What department?
Because they are also entitled. At least let them respond to my request, because I have written 2-3 letters requesting them to consider my petition. It is there on record. They have not even responded anything till date, Lordship. And even
the order you annex is 24/1007. CR producing the letter from Additional Director of Surveys, whereby bank draft so and so for months of November, December were received maintenance of so and so. Informed petitioner said, you go and agitate again before the court. Stop. Heard Mr. P.T. Sangma, the council petitioner. The prayer made out. The prayer in the petition is for
sharing of 50% of retirement benefit.
Take 80%. Why 50%? Is for amendments to issue to state respondents for payment of 50% of the pension amount and time benefits to the petitioner, who is stated to be the wife of the respondent number 3, who has deserted her stock. Approval of the records reveals that as far back 2007, the petitioner had approached the which court is this? Where?
Magistrate first class.
They said magistrate first class.
Had
magistrate
filed an application. Where? Which district? Or in before the assistant magistrate?
Tura,
West Castle Tura, and was allowed maintenance. Mr. P.T. Sangma submits that after that period, no maintenance has been received, nor any payment made to her by respondent number 3. Stopped. Next, Mr. R. Gurung has raised objection to the maintenance petition, submits that the petitioner has
will approach the proper.
Yes, you have the petitioner can propose water remedy for redressal of grievances, which is a continuing right, you'd say.
Yes, Lordship.
Accordingly, matter stands closed, leaving the petitioner giving the petitioner liberty to
approach
appropriate forum.
Lordship.
See, anyway, will not advise. Yes.
Reply obliged.
Item number 2.
Lordship, I filed a petition raising the maintainability of WPC 427. This is the delimitation matter.
Lordship, I'm praying, Lordship, if this matter can be taken up along with the main matter that is listed. Delimitation matter.
End of the board.
Not Lordship, on 27th. The main matter is fixed on 27th, Lordship. And in the meantime, we may be allowed to file a reply to their.
You file a reply, we'll take it up. At what stage is over?
No, it's we have covered almost.
There's no interim order stopping it.
No. We are going ahead.
Miss case number 19/2024, in WPC number 47/23. This miss application has been filed for assuring the maintainability of the connected writ petition. Stop. Mr. S. Chanda, as per appraised funds allowed 2 weeks time to file reply. List the matter on 27th, along with the main case for admission hearing.
Item number 3.
Please, Your Lordship.
Lordship, my apologies for not being here when the matter was called out yesterday, Your Lordship. I had some
When yesterday?
Yesterday it was called out, and I was not here, and so
Yes,
there
yes.
was slight confusion.
You also were not here?
He was on sanction leave, so I thought, and I had some personal matters to attend to. Your Lordship, in this case, Your Lordship, we have, because the assistant counsel was on leave, is still on leave rather, she's traveling.
No, only with regard to, see, that what was the submissions he made on, because in concerns like food distribution, this court
The
concerned
food is
also.
being distributed, Your Lordship.
Just as per my this instruction, Your Lordship, August, September, and October they have made.
No, one thing that now.
Now again they stop.
No, there is no.
After when we filed
supposed
the
to file instructions received by an affidavit as per the order dated 11,
Yes, Your
12,
Lordship.
2023.
Your Lordship, there was a miscommunication because during the vacation, instructions were received by the assistant counsel, Ms. Nonkanri, but she's still on leave and I have joined, but we could
Okay.
not communicate.
This
So
is
I
after-
just
this
need
is after
about
1 week, yes, we to get
about
instructions.
1 week's
And
time.
you asked for striking off of 5 to 7.
Yes, Your Lordship. After my affidavit, I'll,
So Your Lordship, let them file the affidavit then after that.
that we can do that.
Yes, this matter is today due to the absence of the councils yesterday. Inasmuch as no, this matter has been listed today due to the absence of the conducting councils. On the last date fixed, the court was concerned in as much as the matter concerns the distribution of food grains to the public. Next, Mr. Yangi submits that the instructions as received will be filed with affidavit within a period of
10 days.
10
Your
days.
Lordship.
Yes. Just thereafter and so on. So.
Oblige, Your Lordship.
Item number 4.
The other item is also more or less related, Your Lordship.
Your Lordship, item number 4, you received this magistrate inquiries took place, but what is the result? I don't know.
We have not received instructions. Shitara has told you.
What magistrate inquiry?
Regarding this matters of all.
And this matters all, meaning?
All, including this removal of this.
He was temporarily removed as the president of the
This is
Vigilance
together after
Committee.
10 days.
Yes, Your Lordship. Oblige, Your Lordship.
Yes. There are a lot of defects in the petition also have as noticed in the last order. Anyway.
Item number 5.
Yes, MS Alema.
May it please, Your Lordship. Your Lordship, in this case, Your Lordship, I've received instructions, and Your Lordship, the department has no intention of stopping or denying them their rights of performing their religious activities.
Yes,
Your
Mr.
Lordship.
Marpan, you got the instructions?
Instructions, they're supposed to provide their instructions. So
And an NOC
if that is
also
the case,
was
Your Lordship,
obtained,
then in
Your
that
Does
case,
it see instructions?
the state does not have any objection, then an order may be passed to that effect, Your Lordship.
An NOC also was obtained, Your Lordship.
Yes. You file a short affidavit, then
Yes, Your Lordship.
MS Ailingwa submits that as per the instructions received, the department has no intention from stopping or denying or infringing upon the petitioner's rights to perform their religious activities as per the custom and practices. She therefore submits that the apprehension of the petitioners is misplaced. It's further submitted that instructions have been received with regard to the other points, other issues raised in the petition. She praised how much time?
2 weeks, Your
2
Lordship.
weeks time to file the same way of affidavit. Accordingly, this is the matter. After 2 weeks for affidavit is noted that and that's all. Yes, we'll dispose of. Let the affidavit come. We'll put on the record. Okay.
Pleasure.
Daily list item number 1.
Yes.
Please, Your Lordship, pray for some time, Your Lordship.
This matter has been adjourned repeatedly. We'll pass orders ourselves. Or what to do? You agreeable to that?
Lordship, I'm just appearing on
without
behalf-
any arguments, without arguments from the councils.
Shri Lordship, the conducting counsel is on sanction leave.
So you are here now.
He'll be leading us in the
Lordship,
matter, Your Lordship.
I'm also appearing on behalf of Ms. B. Goyal.
Okay, okay. Not on behalf of Mr. K. Paul.
Yeah, Lordship.
Okay. Prayers made on behalf by the parties for adjournment due to personal difficulties. This is the matter up to 2 weeks. Yes.
Lordship, status quo may kindly be extended.
What? The status quo?
Status quo.
The status quo.
Yeah, interim orders, if any, shall stand as. What? Interim orders will be operable till the next date. Yes.
Your Lordship, I only pray may come up after 3 weeks, Your Lordship.
What's happened to the conducting counsel?
He's unwell, Your Lordship.
In hospital?
He's recovering, Your Lordship.
Okay, 3 weeks.
I pledge.
Interim orders continue till next date.
Item number 2.
Your Lordship, item number 2 is also connected to.
Same order.
3.
May it please, Your Lordship. Your Lordship, we have not complied with the court's order till now, Your Lordship, and we have not received anything.
Your Lordship, I pray this matter may be taken up after some time, Your Lordship.
What's the order? For that pension to be that
Yes, Your Lordship.
you accept the report of the police from Mizoram.
Yes, Your Lordship.
Yes.
Your Lordship, I pray if this matter may be taken up after
Well,
some
Dr.
time.
Muzga is here.
Your Lordship is on legs.
After some time.
4.
You wait, don't run away. Yes.
Item number 4.
My lord,
yes.
The petitioner, my lord, she is on leave, so we cannot serve the copy. Otherwise, the affidavits are ready, my lord.
If none appears for the petitioner, Mr. P. Uben submits the affidavits ready. I'll go on this matter after 2 weeks. Yes.
Obliged.
5.
May I please, Your Lordship? Your Lordship, in this matter, I am will play 2 weeks' time, Your Lordship, to file rejoinder affidavit, small rejoinder affidavit, Your Lordship.
MS and Rajiv Praise was allowed to file small rejoinder affidavit filed by the state by the respondent.
6.
Yes, up to 2 weeks.
Much obliged, Your Lordship.
Your Lordship, I've received the affidavit they filed yesterday, Your Lordship, but then, Your Lordship, in the affidavit, so it's not clear, Your Lordship, when it will be considered.
How will we say that? You filed, you.
Yes, Your Lordship, I'll seek time to file the thing, Your Lordship.
Mr. B. also submits that they have just received copy of the affidavit. It is allowed 2 weeks' time to file rejoinder. Just that after it. So on, so.
Obliged.
7.
My lord, I am entering appearance on behalf of respondent number 7, or number 5. Number 5, the managing committee, my lord. My lord, I pray kindly allow me 3 weeks' time to file my counter, my lord. It's regarding a salary, non-payment of salary, but I have instruction that it's not a sanctioned post. So for that, we'll have to counter, my lord.
Yes, under the appearance today.
My lord, my lord.
Yes, Mr. P. Uben has entered appearance on behalf of respondent 5 today. How many respondents are there?
5 respondents, my
You're the
lord.
only 5 respondent.
Yes, my lord.
Such service is complete. What about the government?
Yes, Your Lordship, I filed my affidavit.
You already filed it. When?
Yesterday.
Mr. M. Pala submits that affidavit on behalf of respondent 1 to 4. It's already been filed. This is a matter of 2 weeks. For affidavit by respondent number 5.
If I may submit, I received instruction yesterday from the respondent number 2. If I may be allowed to file an additional affidavit.
Yes, Mr. M. Praise was also permitted to file an additional affidavit if so advised.
Obliged.
I had it valid for 2 weeks, huh? The last line.
8.
May I please, Your Lordship, this matter may be taken up at the bottom of the list, my lord.
Why?
Because they have got instructions, so it can be disposed of.
My lord, I have not been informed by Mr. Bhattacharya that we have received instructions.
Bhattacharya,
We are
he is
to pay
busy.
for time to file affidavit, my lord. So, my lord,
Why? What instruction you received to be disposed?
No, my lord, as per my information, he received some instructions. So on the basis.
Who has received?
this KP Bhattacharya, my lord. His other court is...
My lord, we are yet to file our affidavit in reply in this matter. So, my lord, whatever instruction must have been received, we have to file an affidavit in this particular case.
He's come, yes, Mr. Bhattacharya.
We have to file an affidavit, right? Instruction yet.
My lord, I have received on instructions only yesterday evening, my lord.
What does it say?
My lord, my lord,
Mr. Hazarika says that has settled his case.
Moreover, this, my lord, recently he has passed MTET also, my lord. And it has not received by this concerned office till date. On the basis of this thing, my lord.
Yes, because you're the only single teacher of the school.
Yes, my lord.
My lord.
And moreover, I have passed, my lord, MTET. Result was declared on...
Does it have the sanction of the competent authority?
My lord, that...
A sub-divisional school education officer.
That, of course.
Does it have to come to the director of education or no?
My lord, of course, that part. But there are...
Mr. K.B. Bhattacharya has produced some instructions dated 7 February 2024 from the office of the sub-divisional school education officer, Southwest Garo Hills.
Pass MTET, my lord.
Stop. As per the instructions, it appears that the said sub-divisional school education officer, Ampati, will approve the appointment of petitioner as assistant teacher. More so when the school is run by the said petitioner as a single teacher. The approval accorded as given instructions on the basis of proposal sent by the school management committee on 8/11/2021. Like that, Mr. K.P. Bhattacharya submits and view this development. We have provided to seek instructions from the other respondents.
Normally, my lord, the SDSO is the approving authority.
May I please, your lordship, I refer in my writ petition and Annex 12, page number 56, my lord.
Annex 12.
Annex 12, page number 56, my lord, in my writ petition. Yeah. Shall I read out, my lord?
No need.
He's already, once he's approved, my lord, but from the DSCO has not approved.
Oh yes, on the last line. No, he doesn't need for instructions. It's not required. Yes, Ms. K.V. Service and view this development. Perhaps the writ petition can be closed at this stage.
Yes, ma'am.
Accordingly, writ petition stands closed. The instructions are received and taken on board and made part of the record. Yes.
Item number 9.
Not supposed.
We are waiting for instruction from the government, my lord. We need some more time, my lord.
Instruction from?
From the department.
What's the matter about? Casual worker scheme is I've paid for the 2 weeks time granted to the state response file affidavit this thereafter and so on.
Obliged.
10.
Representation addressed.
My Lord, after 20th December, my Lord, further orders were passed in MCWPC number 10 on last week, my Lord.
My Lord, they are waiting for, means affidavit has to be filed, my Lord.
No, no.
The representation has been disposed of.
The President has been disposed of, my Lord. My Lord, that has been taken note of by your Lordship's order in...
Oh, yes, you mentioned it, no?
My Lord. 6-2, my Lord.
Oh, yes.
It should come on 26th February, my Lord, in terms of this order. We'll file affidavit by then.
Yes, sir. Lisa's matter. In view of the order passed in Miss Case WC number 10, 2024, Lisa's matter on 26th February for affidavit for hearing. Yes.
11.
Please, Your Lordship. This is a case pertaining to seniority, my Lord. Now, my Lord, I have filed a miscase also, my Lord, anticipating that the private respondent might be promoted in the meantime, Your Lordship. Now, so far the miscase is concerned, Your Lordship, I am not pressing it right now, Your Lordship. This may be closed. And, my Lord, only prayer, my Lord, otherwise there may be some complication. Lordship will make an observation, my Lord. Any promotion, my Lord, of the private respondent will be subject to the outcome. Only that,
department?
This is education, Your Lordship.
Miscase. First miscase number 244 or 2023. Mr. S. Sendaner, counsel for the petitioner, submits at this stage the petitioner will be pressing the instant miscase according to the same stance code. What about affidavit by the government?
Not yet, Your Lordship.
But, further 2 weeks' time granted to the state respondents. What about steps?
I have taken steps, Your Lordship.
They received?
Not yet.
See back. Okay, thought miscase agar jama de putar. Find now officer indicates that service report is complete with regard to respondent number 9 and 15. Yes, the service reports awaited on respondents 7, 8 and 10 to 14, whereas for respondent number 6 the notice has returned back unserved. Unserved December 6. Yes, a petitioner to take note and to obtain status or to take fresh steps on respondent number 6. For what reason unserved? Huh? Not correct address and correct address. Huh? You take fresh steps on respondent number 6. Next parameter gave Barachaji praise funds allowed further. 2 weeks time to file the affidavit. Yes.
Lordship, only thing, my Lord, I have to, only the observation, Your Lordship, otherwise lead to a tangle. Any promotion of the private is subject to the outcome.
Any promotions in the of the respondents,
private respondents,
private respondents shall be subject to the result of the repetition. I thought you don't need to say that.
No, otherwise, sometimes there is objection, come and challenge it now. Promotion has been obliged, Your Lordship.
12.
Just see why it has been.
We have taken steps upon the private respondent number 3.
1 second, 1 second. Yes, Ahmed Koni.
My Lord, we are still awaiting for instruction.
So, right, Mr. Yempala. Yempala, correct? Yes, I sent appearance on behalf of respondent number 3 today. So, no further. from today, stop. Appraised funds allowed? 3 weeks time? 2 weeks time to file. Affidavit similar praise made on behalf of the respondents 1 and 2. This is a matter of 2 weeks for affidavits. The interim order passed earlier should continue to the next date.
Okay.
13.
May it please your lordship, in this matter, your lordship, instructions are still awaited. So I'm praying for further 3 weeks time, your lordship.
MSS room thou. Vice room so praise funds allowed for the 3 weeks to file affidavit. For appearance and file affidavit. Just thereafter. Interim order?
Interim order, lordship.
Interim order shall continue to the next date.
High law, lordship. 14 also, lordship, similar.
14.
Second call, item number 3.
Complied?
My lord, it is in the process of compliance because we asked them to submit certain documents, my lord, which yesterday I think their advocate went and submitted, my lord.
Dr. Musika submits that the process of compliance is on. This is a matter of 1 week.
Maybe a little longer, my lord.
Okay, 2 weeks, yes.
It comes after 3 weeks, my lord, I think.
No, 2 weeks. No,
Hearing, supplementary list, item number 6.
I'm not hearing it.
Please, lordship. Just give me the first affidavit.
1 second. Yes.
May it please your lordships. So, my lord, my submission yesterday, if your lordship recollect, there were 2 payments, my lord.
1 second. Sorry. Yes.
Yes.
Looking for the notes, yes.
Submission was that, my lord, following the 6th pay commission, my lord, MHD floated a scheme dated, my lord, 31st December 2018, which was subsequently made part of the regulation framed by the UGC in the year 2010. That was Appendix 1. Now, that categorically say, my lord, the applicability state government can. Now, state government, my lord, admittedly, my lord, adopted it, the pay scale. Very categorically, they say the UGC pay scale we have adopted. Now, so far we are concerned, my lord, we fulfill the UGC norms, and they have extended the UGC pay scale. Now, my lord, what the scheme provided, my lord, 2 payments. 2 payments, my lord. One payment is of rupees, my lord, starting from 15,600 to 39,100. That is meant for, my lord, assistant professors, with different, my lord, academic grade pay, starting from 6,000 in the entry level. Now, these facts, my lord, should not trouble us, my lord, trouble this court much, because these facts have been admitted at page 7 of the first affidavit, your lordship, filed by the state government. They have categorically stated what are the stages. If I can take my lord to page 7, your lordship. Page 7, my lord. Lordship has got it.
Yes.
My lord, I am reading one. Stage 1. Assistant professor with qualification of NAT assessor, pay scale such and such, academic grade. This is the entry level. Now, what is the stage 2, my lord? They are admitting assistant professor with pay scale of C, with academic grade pay of 7,000, eligibility after completing 6 years of regular service with the state college. However, in case of incumbents having PhD, MPhil qualifying service is 4 years, 5 years respectively. Now, my lord, stage 3, assistant professor with pay scale of rupees such and such, with academic grade pay scale of 8,000, my lord. Now, my lord, what I am saying, so these stages, they are not disputing. They are saying this is the things, correct. And my lord, last subparagraph, my lord, they have admitted that this has been given to us. The same is being provided to all deficit college teachers as per the eligibility or fulfillment laid down API criteria. Hence, the petitioner are eligible, the same will be provided. In fact, from the mere perusal of such and such, the writ petitioner, it can be seen that the petitioner have already been placed in their eligibility and therefore whatever is due, they have been paid. So these are not disputed, your lordships. Placing us from stage 1 to stage 2, stage 2 to stage 3, not disputed. So, my lord, I think, my lord, we will not make much submission on these things. These are admitted position. Now, the only question remains, when you place me from stage 1 to stage 2, what the scheme further say, very categorically say placement to higher academic grade will entail increment. Now, how it is to be calculated, further it is provided, it should be calculated as per the decision of the central government. Now, central government had taken a call on this, and whatever the decision central government has taken, this was incorporated in Rule 13 of the Central Civil Service Pay Revision Rules 2000. My lord, I have annexed it, 2010, what's it? That is of 2000, my lord. 2008. 2008. Now, how the calculation is to be done. Now, admitted position, my lord, is these things. Though I have been placed, my lord, we have been placed from grade 1 to grade 2, my lord. I have given the charts as well as the communication by which we have been placed in the higher grades. But admittedly, my lord, they are saying we have not been paid our increments. So, my grievance is here, your lordships. Now, lordship will recall, my lord, I placed. What is the UGC school? That has been defined in the rule of 2010, framed by the UGC. They say UGC scale means the scale as provided in the scheme contained in letter dated 31st December 2008, which was Appendix 1. Now, Appendix 1 is very clear and very elaborate and very categorical.
Okay.
Well, now, your lordships, you can take back your lordship to the writ petition. My lord, I have gone through already, my lord, the adaptation order. That is at page 42, my lord. I will not repeat it. Which clearly, categorically say, my lord, the UGC pay scale has been adopted. Now, if you adopted the UGC pay scale, my lord, you cannot leave out, my lord, it cannot be left out, my lord, the increment. Now, my lord, at page 46, your lordship, just again, my lord, I'm just highlighting this. Page 46, your lordship, paragraph 8 of the letter by which, my lord, the UGC pay scale has been adopted by the state government. It again categorically say, fixation of pay on promotion, placement, or scheme such and such. In case of promotion, placement, upgradation from one academic grade pay to another in the revised pay structure on or after 1st January 2006, the fixation of pay of an employee will be made in accordance with the UGC notification. Now, they are saying it has been clearly spelled out also. If it was not spelled out also, my lord, by implication it follows. But this has to be as per the scheme. Now, here they have categorically again spelled out that these will be as per the UGC. Now, what is UGC, my lord? UGC is relying on the scheme, and the scheme say as per the central government decision, and the central government decision was incorporated in the Central Civil Service Pension Rules of 2008 at Rule 13, your lordships. So, my lord, there is no basis denying me this. Now, one of their submission is this thing, even if we have adopted the scheme, it is not mandatory that everything we should follow. But considering for a second. So for the UGC pay scale, extending the UGC pay scale, my lord, they are not refuting it. They say, no, UGC pay scale we have extended. Now, my lord, UGC pay scale cannot be, my lord, divorce the increment. Increment is part of the scale. Each movement to higher academic grade, my lord, automatically follows. Now you cannot say we will not give you increment. If you are saying we will not give you that increment contemplated in the scale, that amounts to denying me the exact UGC pay scale. So my humble submission, my lord, whether it is mentioned, but it has been categorically mentioned in the adaptation orders.
So what you say, it comes, the entire package comes. You can't have one
Obviously,
package.
it cannot be, my lord. Even if they make a submission, the entire thing we are not supposed to follow. I can sit for a time being, your lordship. But the fact is, this thing they are saying very stoutly. So for UGC pay scale, yes, we have extended. Now, UGC pay scale cannot be divorced this increment. The increment is part of this scale, your lordship. Each movement, it say, will entail a increment.
But
and how it is,
that's your case, that increments are due, and then if they are
exactly, your lordship.
the withholding of increments to you is unjustified.
Unjustified.
If you have accepted this fixation of pay and promotion and placement.
Lordship, exactly. And my lord, in fact, last time our submission was this, that once you adopt the scheme, in entirety you will have to adopt it. So, my lord, without going into it, my lord,
made some submissions about the government not advancing some. Anyway, we'll hear him.
Lordship. Now, my lord, those Annex 3, 4, my lord, their placement. Now, their placement I have already pointed out to your lordship. Read petitioner number 1, 2, and 3, my lord, on which date they were placed, your lordship.
What are you saying?
Annex 3, your lordship. These are the orders, starting from Annex 3, the orders by which, my lord, we have been placed in the higher academic grade.
Okay, senior grade.
3, my lord, dated, my lord, 1/12/2014. Serial number 2, my lord, Amanda B. Basomet. She was placed, my lord, from stage 1 to stage 2 with effect from 1/8/2011. So these are the communications. Now, if your lordship come to the next page, 50. She was further placed, my lord, to the stage 2 to stage 3 with effect from 1/8/2016. Now, so far 1/18/2016, I think, my lord, this is, I mean, this is not for adjudication before this court, because lordship will take note. In the meantime, my lord, 7th Pay Commission has come into effect. That became effective from, with the effect from, my lord, 1/1/2016. And these will hold the field, my lord, till, I think, in 2026, still holding the field. So there is no increment, my lord, other revisions are there. So the government has, whatever benefit is there, my lord, government had acted as per the 7th Pay Commission, your lordship.
So looking at that one portion only now.
Only that one, but whatever
is from 2011 to?
My lord, that is, my lord, 1/1, because so far 6th Pay Commission is concerned, 1/1/2006.
He was a dear placement from stage 1 to stage 2 on 2011. So she'll be entitled on as per 2011.
That time 6th Pay Commission was.
Until 7th Pay Commission came when?
7th Commission came effect from 1/1/2016.
That means for 5 years.
10 years.
11 to?
11, not 11, my lord. 7th Pay Commission, my lord, has been given effective from 1/1/2016, and it will till, my lord, till the last part of, my lord, 25. Because the Pay Commission whole field, my lord, the whole field for 10 years. So, my lord, that would be taken or has already been taken care of by the new Pay Commission. So, whatever has been granted, my lord, after 1/1/2000, after or on 1/1/2016, my lord, that will come within the purview of 7th Pay Commission. So I am not on that. Yes. I am with those placement, my lord, which were made on or before, my lord, 1/1/2016.
Yes.
So admittedly, so far the second placement is concerned, my lord, from stage 2 to stage 3, that happened 1/8/2016. So that was outside the purview of 6th Pay Commission.
Yes.
Now, my lord, if you can take your lordships to page 52. Now, 52, my lord, writ petitioner, serial number 1 and 2 are the writ petitioner number 2 and 3. Now, they have been placed from stage 1 to stage 2 with effect from 16/4/2013. And the third writ petitioner, my lord, at serial number 2, he was placed from first to second stage with effect from 1/6/2014. So, these were within the purview of 6th Pay Commission. So, I am entitled for the increment because 6th Pay Commission was holding the field at that point of time.
Okay.
Now, your lordship, the rule, Annexure 7, my lord. Annexure 7, my lord, I have annexed the extract of, my lord, Central Civil Service Revised Pay Rules, my lord, 2008. It starts actually from page 55, the rules. And the relevant rule, my lord, that is rule 13, deals with the fixation of pay on promotion on or after 1/1/2006. That is at page 56, my lord. We say that in case of promotion from one grade of pay to another in the revised pay structure, the fixation will be done as well. So this is, my lord, admittedly, my lord, from one grade to another grade, higher academic grade, one stage to another stage. So this is what the, my lord, calculation provided by the central government, incorporated in Rule 13, which applies in my case and which is clearly provided, my lord, in the scheme. Scheme clearly says how it will be done, central government decision. Central government decision incorporated in this Rule 13. Now, my lord, if I can take your lordship, I have cited an example. Of course, they are saying we are not supposed to follow what the state of West Bengal has done. Just for a guidance, your lordship, West Bengal, they had extended UGC pay scale to eligible teachers. Now, dear my lord, their notification I have annexed. That is at page, my lord. My lord, it starts from annexure 9, my lord, page 59. Page 59, your lordships. Dated 28th August 2009.
Yes.
Principal Secretary, Government of West Bengal to the Director, Public Instruction, West Bengal. My lord. Now, relevant part, your lordships, at page 62. Lordship. Now, my lord, this is paragraph 8. Fixation of pay on promotion, placement, and benefits on or after 1/1/2. In case of promotion or placement upgradation from one academic grade pay to another in the revised pay structure on or after such fixation, the employee will be made the following manner. The same thing what the central government, your lordship, is the ditto same. How the calculation is to be done. So, my lord, the state of West Bengal has done it. They are under obligation, they will have to do it, my lord. Every state is under, once they extend, they will have to do it. Now, your lordships, if I can take, my lord, in fact, we have approached the authorities, filed several representations, because they are saying that delay, latches and all those things, my lord. Filed several representation. All I have not annexed, my lord. One representation we filed 27th February 2020, that is in annexure 10, your lordships. And this has been responded. This has been responded by the state government favorably.
Excuse me.
My lord, I will just take your lordship to
what's the reply?
To lordship, my lord, 85, page 85, annexure 12. No, this is a letter from the Joint Director, Higher and Technical Education. My lord. Now, they have referred to the different clauses which I have placed before of the scheme of MHRD. Then, my lord, in the concluding part, what they have recommended at page 86. Next page, my lord, page 86. My lord, if I can read the
yes
last two paragraphs, my lord. In view of this, the view of the directorate is that the teachers are well within their right to point out the anomaly as described above, since while extending the UGC pay scale, it seems that the pay fixation formula also needs to be followed totality. In view of the above, the government is requested to kindly extend the promotional increment while promoting the teachers of both government colleges as well as deficit colleges from one stage to the higher stage. So that was the view expressed by the directorate, my lord. And that was communicated by letter dated 24th August 2020.
Yes.
And my lord, we have filed this writ petition in 2022. Now, your lordship is aware, my lord, what happened in 2020, your lordships, because of all those, my lord, restriction induced by, my lord, COVID-induced restrictions and all. So normal activities were seriously disrupted. First thing, my lord, so far delay, they are saying that there is a delay, otherwise, my lord, my humble submission, your lordship, there is no delay. One thing, statutory rights, this is governed by UGC regulation, my lord. So the question of, my lord, waiver, acquiescence, and abandoning our rights will not come. So delay will
when
not
your
come.
right accrued when from 2011, the first time you went from stage 1 to
But that was
stage 2.
communicated by 14, given from 2011, but the letter by which it was communicated 2014. I have communicated, I have filed several representations, and this was responded in the middle August 2020, favorably. So when it was favorably responded, my lord, we were expecting that things would be done. But
No
in the
reason to
meantime,
come to court.
in the meantime, COVID came, nothing happened, and ultimately no other option, my lord, we had to file the representation.
Yes.
So one, my lord, being a statutory right, the delay will not come. Anytime I can come and enforce my rights. Secondly, my lord, there is no delay as such, my humble submission, your lord.
Yes.
Now, my lord, now, my lord, we have, lordship will recollect, I think my learned friend also relied on some judgment. There were basically 3 judgments relied on, your lordships. Now, these 3 judgments, my lord.
Yes.
First judgment, what is the first? The first, oldest judgment.
Yes.
2007.
Yes.
Yes, I have given.
2007-11 SEC 58.
2007-11 SSC. Now, my learned friend, I think, read out the entire judgment, and he was heavily relying on it. Heavily. Now, this was the case, what happened, my lord? The scheme.
Forgot about judgment.
Lordship.
I forgot what does it say?
Yes, my lord. I will just place the fact. Now, what happened in this case, my lord? After the implementation of MHRD, my lord, schemes by the state of Kerala, because MHRD scheme speaks about the age of superannuation also. Now, age of superannuation, my lord, for the central university is much higher than the state. Now, Kerala, what the teacher did, my lord, they filed a writ petition. This is, you have to follow in totality, not a part of it. Just one part you will follow, other, that's not permissible. So you enhance the superannuation age as per the MHRD letter. So that was their grievance, my lord. Ultimately, matter reached Supreme Court. Now, Supreme Court relying on earlier judgment, number one, earlier judgment of 1992, plus, my lord, looking into the language of the resolution by which the MHRD scheme was implemented by the state government, because there in the resolution, my lord, the state of Kerala very categorically mentioned, here the state government of Meghalaya also mentioned, that so far age of superannuation is concerned, we will not accept, we will go by the state government. So Supreme Court looked into it. And ultimately, Supreme Court reading into the resolution came to a finding that, number one, so far this MHRD scheme is concerned, this is an option given to the state government. This is not binding. Secondly, resolution is very specific. Say, so far the age of superannuation, they would go by the state policy. So there is nothing wrong. So decline to interfere. So this is, my lord, the ratio, my lord, what has been laid down in 2007. Now thereafter this one. This is what is the, now, my lord, next decision, my lord, 2022, my lord, SSC online 958. Dr. Bijayan and others versus state. This is also from Kerala. Again, a batch of writ petitions were filed, your lordships.
SEC online.
SSC online.
It's by 958.
958. Lordship has got it.
Indira Banerjee.
Indira Banerjee? Yes, my lord. Yeah. Now, there, my lord, if I can the facts, there, my lord, the same thing happened, superannuation age again. Now, here what happened, my lord, the superannuation should be at par. Though it was already decided, it should be at par with the central universities, since it is provided in the MHRD scheme. Now, there what happened, my lord, in the meantime, UGC and MHRD, my lord, issued a notification. They said that we have received requested from a number of states. They said it's difficult for them to follow the age of superannuation laid down by us. And that was relaxed. That was relaxed by the, and that has been quoted in this judgment, my lord. If I can take your lordship. Yes. If I can take my lot to paragraph 7.
The Government of India.
Yes. The Government of India, through the Ministry of Human Resource Development, brought out a circular bearing number 14 August 2012 under Section 20 of the UGC Act, paragraph 4 and 5 whereof read, and they have quoted this, after taking into consideration the views expressed by several state education ministers during the conference held in 2010, the central government has now decided to delink the condition of enhancement of age superannuation from the payment of central share of 80% areas to the state. 5. Bearing in mind the question of enhancement age of the requirement is exclusively within the domain of the policy-making power of the state government, the issue of age of retirement has been left to the state government to decide at their level. The condition of enhancement of age of superannuation to 65 years, as mentioned in the ministry letter dated 31/12/2008, may be treated as withdrawn for the purpose of seeking reimbursement of central share of areas to be paid to the state university and college teachers. However, the other condition as mentioned in the letter cited above shall continue to apply. So there was a relaxation, had to write, and ultimately Supreme Court has taken note of it, and they have referred to Section 20 of the UGC Act. Now, Section 20 of the UGC Act says, my lord, that any policy formulated by the central government, if it is in conflict with the rules framed by the UGC, in that case, the policy of central government will prevail, not the rules.
Okay.
So Supreme Court took note of that. And now this has happened. So, my lord, what I want to convey here, my lord, the relaxation was there. So, for my case is concerned, my lord, I am concerned only with the UGC pay scale. And it's very stoutly, clearly, categorically in their resolution, they said they have extended the UGC pay scale. In their affidavit, they said, yes, whatever you are entitled, you have got. Now, my contention is, my lord, UGC pay scale includes the area, includes the increment. Now, that cannot be left out.
Okay.
Now, my lord, the last decision, my lord, which we have relied, and that is, my lord, 2022, volume 5 SSC, page 179.
Twenty.
22. Volume 5 SSC.
1 second.
Page 179. There also, my lord, the state of Gujarat, my lord, they have adopted the schemes. Now, my lord, in the matter of appointment of the Vice Chancellor of the State University, they followed the qualification laid down by the state government. They did not follow the UGC regulations. So that ultimately was challenged, my lord, before the Supreme Court. Now, my lord, while Supreme Court dealing with this, in the relevant paragraph, my lord, 27, 28 and 29, my lord, I'll just read. Paragraph 27.
Comparison. 27, 28, okay.
No, she has got it.
Yes, prior to enactment.
Yes, madam. I just read it. Prior to enactment of UGC Regulation 2010, Union Ministry of Human Resource Development laid down a scheme of revision of pay of teachers and equivalent cadres in the universities following 6th Central Pay Commission. The scheme provides a fixed pay of rupees along with special allowance of rupees per month to the Vice Chancellor. Para such and such of the said scheme provides that it is extended to the universities, colleges and other higher institutions coming under the purview of the state legislature, provided the state government wish to adopt and implement the scheme with certain condition. Inter alia, financial assistance from the central government to the extent of 80% of the maintenance expenditure and remaining 20% shall be met by the state government. It is further provides that payment of central assistance for implementing the scheme is subject to the condition that the entire scheme of revision of pay scale together with all conditions to be laid down by the UGC by way of regulation and other guidelines shall be implemented by the state government and the universities thereunder without any modification. 28. In the present case, the state of Gujarat has adopted the same scheme dated 31/12/2008 by resolution dated 11/11/2009, with effect from 1/1/2006, subject to the condition mentioned in the said resolution. Even in the said resolution, the condition number 13 provides that the state government will publish the educational qualification as per the UGC instruction published from time to time, and quality aesthetics, teaching work days, norms, instruction, resolution will have to be implemented. Now, my lord, next 29. It is not in dispute that the SP University is receiving central financial assistance under the scheme, and it is included in the state university receiving central financial assistance as per section 12B of the UGC Act 1950. Therefore, having adopted the UGC scheme and implemented the same and getting central financial assistance to the extent of 80% of the maintenance expenditure, the state government and the SP University are bound by the UGC regulation 2010. The UGC regulation...
Last time Mr. Bharati said that they are getting full assistance, is that correct?
No, now he has filed corrected himself.
My lord,
he is receiving.
That was where, my lord, the proceeding had come to a halt, my lord. Therefore, thereafter, my lord, I have filed an additional affidavit bringing certain facts on record. However, my lord, because there was a time frame within which I had to file. My lord, one annexure I could not include. My lord, but I have it with you. I have it with me, my lord.
No, my lord, just completed. The UGC Regulation 2000 are superseded by UGC Regulation 2018. However, the eligibility criteria for the post of Vice Chancellor and constitution of the search committee for appointment of a Vice Chancellor remains the same. Therefore, the state of Gujarat and the university thereunder, including SBN, are bound to follow the UGC Regulation 2010, such and such. Here the appointment was set aside, Your Lordship. Then another paragraph I will read, 50. Paragraph 50, Your Lordship. It cannot be disputed that the UGC regulations are enacted by the UGC in exercise of the power under section such and such of the UGC Act 1956. Even as per the UGC Act, every rule or regulation made under the Act shall be laid before the House of Parliament. Therefore, being a subordinate legislation, UGC regulation becomes part of the Act. In case of any conflict between the state legislation and the central legislation shall prevail by applying the rule principle of repugnancy as enunciated in Article 254 of the Constitution, as subject education is in the concurrent place of the 7th schedule of the Constitution. Therefore, any appointment of the Vice Chancellor contrary to the provision of the UGC regulation cannot be said to be in violation of the statutory provision warranting a writ of quorum. Now, my lord, here is the case, my lord. They have gone to this extent, my lord. Supreme Court has held that even if we are required to frame a rules and your rules is contrary to the regulations made by the UGC, my lord, the regulation of the UGC shall prevail. So, my lord, here we need not go to that extent, your lordship. Here, my lord, it's not the question. I am not pleading anymore, your lordship, that you have followed one part.
Simply is that if you're in for a penny, in for the pound.
Exactly, your lordship.
It's like that.
Exactly.
Simple
You have said, you are stoutly saying UGC scale. Now, what is the UGC scale, my lord? That is provided in the rules. This increment is part of the UGC scales. If you are placing me in the house, you cannot say that this is something else. So, we need not go to this extent. Now, my lord, the last blank of my submission, he raised some technical question. Before I answer, I'll just wonder. One thing, your lordship, while I move this writ petition, my lord has asked me why you clubbed together 3 writ petitioners. They are from Shillong College, Senate College and all. Now, my lord, we look here, my lord. We have this thing, common cause, your lordships. All the way assistant teachers, when this placement were made, all of us were holding the post of assistant professor, and all of us were in sanctioned post in deficit colleges, Shillong colleges and Senate colleges, my lord. This is the thing. Now, my lord, suppose, and our representation also, common representation also answered, my lord, by a common order. Now, my lord, suppose, my lord, I had filed 3 separate writ petitions. Lordship would have clubbed them together, and Lordship would have decided, because this is a common issue, man, would have decided it by a common judgment. Now, my lord, this is what, my lord, we normally, my lord, we follow the procedure prescribed in the CPC. Now, CPC, my lord, if I can read it again, your lordship, is categorically provided. Order 1. Order 1, Rule 6, my lord. Who may be joined as plaintiff? All persons may be joined as one in the suit as plaintiffs where A, any right to relief in respect of arising out of the same act or
You
transaction.
mean to say that Mr. Barisa is raising serious
Yes,
contentions about this matter on this ground that the three petitions come together? You paid the court fees, but correct?
Yes, that I have paid, Your Worship. I cannot. He is pleading, my lord, if I can say, my lord, he has taken the cue from this court. So this court has initially objected. Just ask me why not separate. So he made a elaborate statement in his report. But anyway, my lord, just let me complete. It's interesting otherwise. Any right to relief in respect of arising out of the same act or transaction or series of act transaction is alleged to exist in such person, whether jointly several. B is important, my lord. If such person brought separate suit, any common question of law or fact would arise. So here is the same thing, my lord. Why you join together? If I had brought my separate actions, lordship would have clubbed them together, and single issue, my lord, as a single issue, lordship would have decided it. So, my lord, that cannot be a ground. That cannot be a ground, my humble submission.
Anything else?
And my lord, delay, my lord, I have answered. Delay, I have answered. Anything, my lord, right this much. Anything new, my lord, lordship will give me. Anything new he brings in.
Yes. Just give me 2 minutes. Just 2 minutes. I'll just come back. Sitting for too long, my back is. What happened to the councils? Call them, call Mr. Kiwi. Semaing, semaing. Semaing, semaing. Ma'am? Or address all ready for the hearings? Ready?
My case is already, it has been heard, and I filed my written argument also.
What an argument? I told you go for settlement or you're going to get zero.
Yes, Your Lordship. And, but,
you want zero?
Yes, Your Lordship.
You want zero? Okay, then take zero.
I have tried to convince her, but I didn't got any.
You'll get zero only, that means. Yes. Second half, the court won't sit because we have some meetings, and we are expecting the new incumbent.
Madam. Second half.
Yes. I think we'll pose other matters after 1 week, so as not to hold you back. Yes. Any urgency? Any urgent matter?
Nothing urgent, Your Lordship, but 30 and 31 is there, which has not been adjourned. So.
Yes. No, we'll post it after because it'll take some time, I think, and because we have some meetings lined up and difficult.
I've also got some religious function to attend to, so I take, with your permission,
after
I can
1 week,
take
yes,
leave.
yes.
Thank you.
After 1 week, yes. No urgency, no urgent matters. Mr. Nongpur, urgent matter.
You can wait for a week.
Okay. Yes. Okay. Yes.
Wait, please, just one small point, Your Lordship. Now, my Lord, my learned friend also very casual statements that necessary parties. Now, here, my Lord, MHRD, I made them a party. MHRD, I made them. The scheme was formulated by MHRD. So I made them a party by way of abundant caution, though that was not required. Sabre copy, but they never appeared, my Lord. So they are not controverting the state. Lordships.
Only one thing which I remember, if Mr. K.P. Varche last time said that why incomes are given because they never received that 80% share.
Now the correct.
Then let him clarify that.
No, one more small last thing. He is also saying that management, college management and all. Now college management they have admitted. So for pay fixation, college management has no rule. If I can take my Lord to one paragraph of their affidavit. Now my Lord, at page 5, Your Lordship, this is a long paragraph, last sub-paragraph of page 5 of their affidavit. Page 5, my Lord, the last sub-paragraph.
Yes.
In the page. In this regard, it may be appropriate to mention here, as per the usual norms and practice, as per the pay fixation of the incumbents were normally being done by the respective colleges, the same are thereafter sent to the government fund. But in recent times, certain objection has been raised by the Directorate of Local Fund Audit regarding such fixation, as such anomalies have been found which request to be regulated. Therefore, the Education Department along with Local Fund Audit are in the process of streamlining the matter relating to pay fixation deficit of the college. So entire thing is with the government. Local Audit is a party here, Your Lordship. Management has no rule. So what he is saying that my Lord, there should have been a party is not correct. Now coming back to UGC, my Lord, UGC has no rule. Only their regulations. Regulation I am relying, my Lord. It is the MHRD, but they have not appeared. That's all, my Lord.
Yes.
On the last occasion,
yes,
there was because I had argued, my Lord, that the state did not receive any.
I don't remember anything now. After New Year, everything blank slate. Getting old now, it's not like before. What do you say, Mr. Sen? Now getting old, so getting slow also.
Very difficult. Often I say this to my junior colleagues and all, they laugh at me, but this is a fact of life.
Yes. So you have to, refresh. Yes.
My Lord, if I'm allowed to start, my Lord, if
Of course,
I would
waiting,
refer to,
waiting for you to start.
my Lord, I would refer to the latest affidavit which was filed, my Lord, on 3/11/23, my Lord.
This is affidavit.
My Lord, this is filed on.
Oh, he's got it.
Yes, my Lord. It is a short affidavit, in fact, my Lord. My Lord, if I am allowed to read from para 2, my Lord, which is at page 3.
You submit. Why you want to read?
My Lord, the first notification, my Lord, by which the UGC regulations were adopted, my Lord, it is...
Why you say the opponent here and tenders unconditional apology for the...
My Lord, in the earlier occasion, one affidavit was filed stating that no fund was received, my Lord. So thereafter, my Lord, when a query had fallen from this Honorable Court, my Lord, I had approached the department that you please check everything and please place everything in order. Then, my Lord, after examination, they found that the government has received fund. In fact, they have received fund also, and it's too utilized also. And my Lord, the UGC, my Lord, the release of the fund also, my Lord, there is a very long process. There is proper scrutiny, whether everything has been compliant or not.
Of course, that.
Only then, my Lord, the fund is released. Now, my Lord, in this event, my Lord, this has already occurred. There was a detailed scrutiny. That's why, my Lord, because that letter I could not include with this affidavit because there was a time frame within which I had to file, my Lord. It was not before me. So, my Lord, there is a small note which has been prepared, my Lord. I'll give a copy to my senior also, my Lord. So, my Lord will kindly see the body or the authority which is financing, which is providing the finance. They did not find, while, my Lord, before releasing the fund, there was a detailed scrutiny. My Lord, they did not find any violation, my Lord. Their finding is that it's in whatever has been followed by the government of Meghalaya as far as the 2010 is concerned, everything is in order. And
no, because they concern 80% only of the amount.
My Lord, 80%, 20%. That comes to 100%, my Lord. 20% was also given by the government, contributed by the government. The whole money is already utilized, my Lord. Now, whether, my Lord, at this stage in 2022, this issue can be raked up, my Lord.
Okay.
They are in fact too late, my Lord. If I am allowed to, my Lord, this annexure, this...
So you base your first argument as a steel claim now?
Yes, my Lord. Funds have been released. Everything stands utilized. Now, my Lord, that budgetary allocation, that itself is gone. At this point, my Lord, because there has to be, for any salary, my Lord, there has to be budget allocation, my Lord. Now, this event has gone by long back, passed by, my Lord. These issues ought to have been raised at that point of time. My Lord, this in this additional affidavit which I filed, we had enclosed the first notification.
What does this note, let's just, what does the note say?
My Lord, the note says that, my Lord, the government of Meghalaya has released an amount of...
When is this?
My Lord, this was... This happened in 2016, my Lord. 2000... This is pertaining to the 2010, the recommendations, my Lord, the UGC regulations. My Lord will get the picture, my Lord, if my Lord kindly comes to, my Lord, the typed copy of annexure 2, my Lord. Sorry, the pagination. Apologies, my Lord. That will be after page. The typed copy of the UGC letter, my Lord, where the fund was released. New Delhi, that is second last page, my Lord, that is 16 December 2016.
Yes, what does it say?
If I am allowed to read, my Lord.
Yes.
Release of financial assistance to meet 80% of additional expenditure for implementation of revision of pay scales of university and college teachers in the state of Meghalaya. I am directed that the decision guidelines of Government of India regarding revision of pay scales and other terms and conditions of service of university and college teachers was conveyed to the state government by department's letter dated 31st December 2008. The states were informed that the central government would provide financial assistance to them to the extent of 80% of additional expenditure involved in implementation of the scheme for the period of 1/1/2006 to 31/3/2010, subject to fulfillment of certain prescribed terms and conditions. In pursuance of this, Government of Meghalaya has decided to implement the scheme of revision of pay scales for the university and college teachers in the state and has submitted a copy of the orders issued by it in this regard to the central government for approval. The orders issued by the state government in this behalf has been examined and found to be in conformity with the relevant correspondence stipulations in the department scheme. In view of this, it has been decided to release an amount of rupees 45 crore 57 lakhs 41,316 only against the total central share, and 80% of the additional, that is, this will be, my lord, 59 crores 96 lakhs 70,647 Meghalaya as first installment on account basis for implementation of the above schemes. The sanction of the President is hereby accorded to the payment of such and such amount to Meghalaya to enable it to meet additional expenditure involved in implementation of scheme during the period from 1/1/2006 to 31/3/2010. So this assistance was for that period, my lord. This amount would be utilized by the state government in accordance with the terms and conditions stipulated in this department's letter referred to above and the UGC notification dated 36/2010. So, my lord, this whatever fund, my lord, because this is a reimbursement, my lord. So all funds stood utilized. The central government, after, my lord, the Ministry of Human Resource, after going through all the formalities, my lord, they have decided that everything was in conformity, and thereafter the fund was released. My lord, the financing authority.
After 2010, entire burden is borne by the state.
My lord.
For the teachers, the college teachers.
For all, my lord. Till 2016.
That means, sir, the entire liability accruing defects also. That means 20 also.
And here we are in 2024, my lord. Writ petition is filed is 2020.
Now these writ petitions entered service in the late 90s. Late 90s, I mean, because, yes, okay.
So, my lord, if there was any anomaly, my lord, this anomaly could have been found by the financing authority.
Then it's not their fault.
The financing authority did not file any anomaly.
It's not their fault. How can it be their fault?
And whatever is there, my lord.
Even because from your own admission that yes, we are implementing it in its totality, correct?
My lord.
By the correspondence on, that's been shown by the petitioner. So that is the only thing. If you have agreed in principle to allow the entire pay revision, once you allow it, whatever comes together with it.
But my lord, my respectful submission, my lord, if a certain rule is not being followed, or there is a non-conformity of any of the conditions, my lord, who could have pointed out, my lord? It is the financing authority, the Ministry of Human Resources.
So you say that because due to that has been overlooked by them, that means that there's no liability any longer.
My lord, that episode is over, my lord.
It creates a problem for you because this refers to a certain period which has lapsed and
exactly,
money also gone. There's a question of of opening
exactly,
the old book again.
That is exactly the point, my lord.
Okay.
Because this whole chapter is closed, my lord. Everything has been accounted. State has given its 20%.
Came to court when in 22. The representation was filed when, Mr. Sen?
And that communication, my lord, favorable communication was August 2020. So
well,
after that communication, we are expecting something would happen, never happened.
But you said the 7 pay commission came 16.
Yes. Their representation is 20.
16. So pay commission came 16. That means that this increment thing wasn't mentioned there. Only that we will imply revision. That means maybe they're talking about 7 pay commission. Yeah. How can it reflect?
No, it cannot be, because 6 pay commission was holding field till, my lord, 31st December 2015. That was holding the position filled. So whatever this promotion from one stage to another during this period had happened, I am entitled.
No, entitlement may be entitled, but regard to you sleeping with your rights.
Exactly.
No, my lord, this is again lost.
And with regard to now to reopening a closed account.
Closed account, my lord.
What I will say, my lord, these, my lord, I have filed representation. August 2020, there was a communication from the government. The government expressed its view. The joint director expressed his view. That yes, they are entitled. And ask the finance. Here your lordship will do the Directorate of Education asking the finance, grant them the promotional.
Yeah, but then the objection has come now. It's being voiced by Mr. Bharatati.
No, I will come to this letter. He has not read. These letter further say this reimbursement with respect to that period, my lord. He has not read all. Now further they say this amount is sanctioned subject to following condition. Again they are saying strictly comply with that MHRD. It is there, my lord. I will read it. I have noted it.
No, I have also
And then
gone
he
through
cannot
the letter.
deviate from.
I have also gone through that letter, my lord.
This has to come by way of affidavit then.
Well,
I have also gone
I
through
don't
it.
think.
Otherwise,
I have also gone through it.
Never end.
Never end. Why are you producing these things now?
No, my lord, what effect this will have? Lord, if I can read it, my lord, just let me read. Let me read.
I may be allowed to.
Reply.
I may be allowed to.
Okay. I will reply, your lordship.
So, my lord, representation, my senior has stated that several representations were filed, but my lord, none of them are on record. The only representation which is on record is in the year 2020. Perhaps they themselves were not aware, my lord.
Yes.
Suddenly one fine day that they realize that maybe this is one opportunity we can approach the Honorable Court, my lord. Then thereafter they file a representation. And representation also, the government does not say, my lord, that the answer representation is not answered saying that yes, it has been granted, my lord. What does the answer say, my lord? Page 86, my lord. This was issued by the joint director.
86 of the writ petition?
My lord, 85, 86 of the writ petition, my lord. This is only a view, my lord. The view of this directorate.
Yes. Is it about the
teachers are well within their rights to point out anomaly. So this is a certain anomaly which they are pointing out, my lord. Point out the anomaly so described above, since while extending the UGC pay scales, it seems that pay fixation formula also needs to be followed in totality. In view of the above, government is requested, my lord, it does not say it's already granted. In view of the above, the government is requested to kindly extend the promotional increment while promoting the teachers of both colleges as well as deficit grant in 8 colleges from one stage to higher stage, except for promotion for pay band 3 to pay band 4 as per EGC regulation 2010. So, my lord, this is only a view of the directorate, my lord. Office of the directorate. Now, my lord, if we assume a situation,
entitlement is clear. Only thing is that how the whole thing unraveled. You understand? Like whether they can be held to be liable for sleeping with the rights, that the rights have been extinguished. You understand? You have to argue. Now that is a point you're making.
my lord.
That whatever it is, you're not questioning about the eligibility to avail of that increment. The only thing is that is a thing. Even by your own response is that yes, they are entitled to the promotional increment. But the manner in which it has been done, whether it can deprive them, whether it can still be granted to them at this stage, or whether they are not entitled any longer, that will be the only part I think to argue. This is correct.
My respectful submission, my lord, it will not be granted because it cannot be opened at this stage, my lord, because this is not a question
argue on that. You have authorities on that.
My lord, of course, I will have to get, because my lord will kindly see. This is not a question of 3 writ petitioners. They have approached. It is understood, my lord. But it will cover all other teachers, my lord. All other lecturers.
See, financial burden, whatever, if entitlement is there and is found that it is valid, the consequences the state will have to face.
Because now, my lord,
money,
will kindly
you can't
see
say
if, my lord, if there is a finding, with due respect, my lord, that there is certain anomaly, my lord. Now, what will be the financial implication?
No, and forget of financial implication. The court's concerned about rights. That's all.
But, my lord, the rights.
And what are the rights?
The rights they should have exercised.
So that's why now you have to show the court that they have not, exercised their rights in such a manner as to entitle them at this stage now.
Yes, my lord.
Though they might be entitled at that relevant point of time, but they have not exercised the rights. And not exercising the rights that time means maybe they might be ignorant, but it was incumbent upon the respondents also to see that, if we are adopting a certain prefixation formula, then that whatever comes with it should have been given to them. So deprivation, now they're coming. So that's only
my lord will kindly appreciate, because
gray area is.
My lord, there was a certain budgetary allocation. Government has, my lord, made certain expenditures. My lord, in fact, my lord, the whole expenditure, which that is of 5 crores.
45 crores.
For 50, my lord, total comes to around, my lord, 59 crores. My lord, what had happened, this was the amount which was, my lord, used by the government.
For 6 years. How many years?
Yes, my lord, for 5 years.
5 years.
So that is from a period of 1/1/2006 to 31/3/2010. Government has already utilized this money in terms of salary, increment,
right.
Everything, my lord. So that came to around, so this was the calculation which was...
Where is UGC now?
UGC is not there.
It's not made party?
It's not made a party. This objection I had raised on the last occasion also, my lord. But my senior had stated that they are not a necessary party. So they should not have been made a party. So my lord will kindly see, this was the amount which was expenditure which was...
You say they have to unravel it, and there's some liabilities to settle with them also. 80% liability for that payment, 20% for the state. Then, anyway, continue.
Because my lord will kindly see this budgetary allocation, this was the amount which was ultimately spent by the government. This amount was spent on everything, my lord, from scale of pay to increments to all other amenities which they are entitled, which the teachers are entitled. This amount was utilized. Only thereafter. My lord, fund is not released before. It is not a case, my lord, where fund is released beforehand. My lord will kindly see, 2010 fund is released in 2016.
That means you should have factored in that increment when you requested the funds.
My lord,
if that is your case.
In my respectful submission, my lord, as per the government, everything was taken.
I mean, skip the radar of the government regarding its promotional increment. In spite of adopting it, in spite of adopting the prefixation.
My lord, if that be so, my lord, then my respectful submission would be also that in that case, my lord, it may have skipped the attention of the MHRD as well, my lord. Because even they did not, there is not a single remark in the letter saying that government has failed to follow as far as the promotional increment is concerned.
Not failed to follow. That component for promotional increments has not been given in the request for funds. Anyway, continue, yes. What else?
So my first point would be delay, my lord, delay and latches.
Okay.
At this point...
Delay, and the representation came on in 2020.
Only 2020, my lord. The representation is an afterthought, my lord.
Yes.
This was never thought of before.
Yes.
Because if this issue was there, that it should have been raised then and there.
And funds already used since?
Funds is already utilized.
And this period for them is from 2000 and?
This is 2001.
No, for the from stage 1 to stage 2.
Because that they are not denying that they did not get. My lord, that is at annexure 3, page 49 of the writ petition, my lord. Date of joining of the petitioner number 1 was, my lord, 1/8/2005. And then she was entitled for senior grade placement from stage 1 to stage 2. That is from 6,000 to direct to 7,000 AGP is, my lord, on 1/8/2011.
So 2011, first one is okay. Petition number 1, 2011.
Yes.
Within that period. Then number 2, this is at page 52.
Number 2 is, my lord, at page 52, my lord.
13?
Yes,
14.
that is at date of joining was 2007 and senior grade. My lord,
So by the time
you've
the
given
next
its-
placement came for grade 3, all the new pay commission already come out. So what you concerns only one grade, that means? Only one promotional increment.
11, 13, 14.
Only one promotional increment, that means. Yes.
Others would be taken care or has been taken care by whatever recommendation in the reflected in 7th Pay Commission.
Yes. This one is Shillong College and the other two are in Synod College.
Synod College, my lord.
Okay, but the others have not come for the court. There's Ivor Lang Dakhar and Lucy Mary Jerva.
Yes, my lord, there are a lot of them. So none of them are before this honorable court.
There's a test case, this one.
Yes, my lord.
Yes, continue. What more you have to say?
This is one major part, my lord.
Delay.
Delay.
So you have any authorities on delay?
My lord, I have, my lord, but of course today
You're
I
going
do
to
not.
substantiate the argument?
My lord, of course today I do not have.
With regard to financial, this is more specifically regard to, like financial allocation and, and spending, that kind of thing.
Yes,
That
my
is
lord.
because prima facie, they are entitled to it. It was not given. Now, how can they be deprived of it? It has to be based on some, a reasonable kind of, on reasons. That you have to show.
Lord, of course that I have
can't-
to look
can't
for.
show.
No, I have to look for some judgments. Of course, today I
But
do not
supposed
have.
to come prepared because this matter has been hanging since May 2023.
My lord, in fact,
I don't think
in
I've
fact,
heard any
most
other
of the
matter,
judgments.
any other matter as long as
in
this.
fact, my lord, most of
as
these.
long as this case, I don't think any other matter.
Most of these judgments, my lord, placed by my senior were also placed by me, my lord, in the.
That's besides the point. Those are different points.
On this issue, my lord.
The delay is a different aspect.
So, my lord,
But that seems to be a most important point. And with regard to the financial.
There will be huge financial implication, my lord.
Not a financial implication. That is the court is not bothered about that really. It happen to some rifles. Final implication out there because of one order of the court due to thousands and thousands of crores.
My lord.
Not only
My lord, but here is a case, my lord, where the funds have already been utilized, my lord, and government has bona fide. It's not that, my lord, the government
Then it
has.
can
There
be
is no
quite
cheating in that, my lord.
one promotional increment for how many years? 5 years. It'll be how much? It'll come to one person.
It comes, I talk to my clients, what they've provided, it comes around, my lord, 300 rupees. 300 rupees. And my lord, kind of petition, I mean, teachers situated like this writ petition, it won't be more than 100. So even if there is a implication, if all the teacher, I doubt, if they come tomorrow, suppose your lordship grants a relief, it won't be more than 2 crores rupees. It's more of a teachers coming, my lord, I'm telling you honestly, your lordship, more of a teachers coming, they feel they were slighted. They feel their right has been violated. It's not financial consequences, hardly anything.
But my lord will kindly
It's
see.
not, my lord, 10 crores, 20 crores, 30 crores,
But
nothing
my
like
lord will kindly see. It is also not a case of pick and choose, my lord. This treatment is meted out to all alike, my lord. Whether it's a government.
Not pick and choose.
My lord.
A question of entitlement, a question of vested rights acquired by virtue of the adoption of certain pay fixation, and then that was you didn't ask for any exclusion or exemption from certain
My lord,
from the pay fixation.
Other ground that we had taken, my lord, is that.
Or continue on delay. Achha. Next point.
On the other ground, we had taken, my lord, that there was no notification issued from the government adopting the central, my lord, pay commission rules, my lord.
What is central pay commission rules?
My lord,
CCS rules.
CCS rules. My lord. There is no notification, my lord. If I can.
But if this UGC this regulation has been adopted and that appendix 1, which is a letter of the MHRD, has been adopted and made part of the UGC regulations, that means if you afford them UGC pay, then how can you deny them this segment? I mean
If I can take, my lord, to the notification which was issued by the Governor of Meghalaya, my lord. This 22nd March 2010. This is the actual notification, my lord, which is also annexed in my additional affidavit, my lord, dated 3/11/2023. My lord, this is dated 22nd March. 22nd March, my lord, this is annexure A1, my lord, page 6.
About this note, you finish the note, you don't want...
No, my lord, note, because this is also part of the note, my lord.
This note I'll read out, my lord.
This
Read
note,
it, follow this. It was issued in 16, again they are saying, please follow that.
The government, if I'm allowed to read the notification, my lord, the typed copy will be more clear, which is at page 7, my lord.
Page
7 of the additional affidavit, my lord.
Okay.
Because this is also included in this note.
It's got only 5 pages. Page 7. Page Annex A1.
Annexure A1, my lord.
Okay, read it.
The Governor of Meghalaya is pleased to order adoption and implementation of the GGC regulations as per the Government of India's letter, circular number so-and-so dated 31/12/2008 relating to revision of pay scale, minimum qualifications for appointment of teachers in colleges and other measures as mentioned in para 2B and 4.1 and 3 of the above said letter circular for maintenance of standards. My lord, this is the primary objective, my lord. Maintenance of standards in education in the state of Meghalaya. The UGC scale of pay. What is adopted actually, my lord? The UGC scale of pay and DA at central government rates shall be applicable to all eligible teachers of government colleges of Meghalaya on submission of option of the age of superannuation shall be as applicable to the state government employees. Pay and DA of college teachers covered by scheme shall be fixed in UGC revised scales of pay with effect from 1/1/2006. The payment of arrears would be made as and when the sources of the state are available through a separate notification. The instructions in para 1 above shall also be extended to eligible teachers of deficit colleges in the state of Meghalaya, and status code be maintained in respect of age of superannuation 60 years.
What do you want to show about this notification?
So, my lord, in this notification, we'll kindly see, my lord,
it helps them.
Specifically mentions about, my lord, pay and DA. DNS announced this is the primary thing which is adopted, my lord. Pay and DA of the college.
Which increment is not mentioned there.
Yes, my lord. There is no mention of increment.
If we say the government may us please to order adoption implementation of UGC norms for government India, so this the 31/12/2008, the same one referred to by Mrs. Sen during revision of pay scale minimum qualifications. So that means if the whole package is to be adopted again, 31/12/2008 speaks of everything, correct?
So
and how can you segregate and say that this notification has sort of modified the 31/12/2008?
So, my lord, if that be so, my lord, because this is issued earlier, my lord. This letter is this notification came first.
Came first before regulation.
Yes, of course. The UGC regulations came thereafter, my lord. That was, of course, another limb of argument that I had made before this honorable court in the earlier occasion, my lord. My lord, actually at this point, my lord, my primary argument would be, my lord, that delay would be one of the major factors, my lord. Delay would be one of the major factors. Funds already executed and utilized, my lord. The Ministry of HRD did not find any anomaly in the following of the scheme. They did not point out any...
what do you want to show from the notes, from the other documents you brought?
My lord, that note My lord, if I am allowed to read the note, because the first para is important, second para is of course pertaining to the 7th Pay Commission, my lord. My lord, point number 1 was Government of Meghalaya has released an amount of rupees 56 crores 96 lakhs 76,645, of which 45 crores 57 lakhs 41,316, 80% bond by the central government. Rupees 11 crores 39,000 39 lakhs 35,320 bond by the state government. So what it means, these are, my lord, the above being the arrears in the UGC scale of pay and DA at central government rates, along with arrears on placement, increment and incentives on acquiring MPhil, PhD with effect from 1/1/2006 to 31/3/2010 for teachers in colleges and deposit colleges. Ministry of Human Resource Development Department has reimbursed. So this is that letter, my lord. Has reimbursed wide letter dated 16/12/2016 the amount of rupees 45 crores 57 lakhs for 41,316.
Were you reading?
My lord, I had taken to the first page, my lord.
First page is where you getting the date from? Extension? Okay, 16/12/2016. Okay.
My lord has found it, my lord. So this is the note actually. So because this letter.
The reason for the prohibition, that's what I'm looking for that. However, government has able to pull the reimbursement salary share of one for amount of 38 crores, which later the government has not been released. Instead, what's this? What sense? What is the 7th Pay Commission? We are not bothered. The second part will
No, we are not bothered.
Then,
so that can be omitted. That is not, so I am not placing any reliance on that. This was the overall note which I later on got from the department.
continue. See, that notification you're reading, 2010, now you say, it refers to Appendix 1 only. Upward movement, assistant professor to associate professors, then that increment at para 8. This letter covers everything. This published in 18 September 2010. That is your argument. That since then the regulations were published in 18 September 2010,
this was the
notification it came out on 22nd March 2010, but refers to the 31st 2008 letter of the MHRD.
This was.
How can you evade it?
Only
on delay you might have a point. Otherwise,
well, these were the stands which were taken by the state.
Okay, you give them notional amount then, one fixed lump sum notional amount.
Yes, my lord,
1 lakh each.
As far as appendix.
Mr. Sen, take notional fixed amount 1 lakh each.
As far as
it's not money. I don't think, my lord, that money is,
why not?
is very
very
less.
We will accept your entitlement and say that
what
yes, like the material shows that, but because of delay it has been caused by you approaching, and I think right. So okay, you fix a notional amount of 50,000 to be paid to all these people who are entitled at the relevant point of time.
Frankly, I consider. I asked them why you come for that small thing. They also considered, my lord, it comes around 200 to 300 rupees. What they feel slighted, my lord.
Per increment for the 5 years.
Yes. Well, what they feel slighted, your lordships, the way they have been ignored. They have pointed out the way they have been ignored, my lord, way they are right.
They have never represented. If they agitated right from before,
exactly,
and they have been ignored, then again it's mislighted. In this case, it's like, okay, fine, we understand.
No, my lord. Here you see, but is it necessary, Your Lordship? Lordship will look into one thing in my writ petition. In my writ petition, I have named that several representations were filed. But I am not supposed to annex all of them. Why? Because my last representation was favorably responded. And that I have annexed.
Right.
So that gives me a cause of action. It starts from there. It's not that I have not filed. What he is saying is true. There are several representations, but earlier representation I have not annexed. Well, these become inconsequential because ultimately this was answered.
If they were answered,
that is a different thing.
If they were never answered earlier on, what prevented you from coming to court then?
Exactly, my lord.
If you never answered before, what prevented you from coming to court then?
No,
if you say that from 2010 onwards, come to court
no.
then.
Exactly. Will your lordship...
Representations, so court has held, and umpteen cases, representation does not mean anything.
No, I understand. But
unless
here,
you agitate your right in a positive
here I am saying, my lord, several representation will not cover delay. There cannot be delay in this case. What, my lord, that Gujarat says, statutory rules.
Number two, it's not a continuing right. It's not pension. One thing is that entitlement, Mr. Sen, we are not talking about entitlement. The court is more or less
delay, my lord. I understand. Yes, what do you lordship?
That's the thing.
I'll show you lordship.
So we'll give you notional amount of.
There is no. But statutory rights, can there be a delay? Now, what the Gujarat, my lord, that decision, that Vice Chancellor's appointment was set aside, they say UGC regulation hold the field. Even if the state government have a separate set of rule, doctrine of repugnancy will apply. This is under the rules.
Not talking about doctrine of repugnancy. I'm talking about your particular case, particular facts of your case, with regard to that even on their part, you see, it's not that they were slighted. Even on their part, this was not detected. You understand? It was never detected about this part. They were in the happily thinking that they had incorporated and adopted the entire pay fixation formula, and that we're getting. And then even the requirements from the UGC also was based on that premise, on that belief. But then their belief was belied that in the sense that now you've come after 10 years and said that, hey, where's my money? You know, that kind of thing. And they say, oh, now they come to court courses. Yes, I mean, statutory right. I mean, if they adopted the 31/12/2008 letter or that appendix, they are bound. But then bound, but now looking into a peripheral case, then maybe.
No, but the other question will ultimately come. This is a right. Can it be defeated by delay? This is just not an ordinary right. This is a right under the statutes.
Even if the right, you don't agitate it, it can be by delay.
No,
even the
statutory right cannot be.
It has to be asserted.
Statutory right cannot be, Your Lordship. And what about the Your Lordship? Lordship, he is answerable. No, what about the...
This is based on letter.
No.
2008. It is not a statute.
My lord.
Only the regulation.
I could not please it, Your Lordship. Lordship will look into, number one, these has been incorporated as Appendix 1 to the rules framed by the UGC, pursuant to the power given to them under the UGC Act.
They adopted it before the regulation came out.
I'm coming to that, Lordship. Lordship will look into the opening paragraph. That's why I say opening paragraph of this scheme is very important. Now, opening paragraph of the scheme, what did it say? Opening paragraph of the scheme say, these revision will be subject to the provision contained in the scheme, number one, and rules to be framed by the UGC. Rules to be framed by the UGC. That they have deliberately used future tense. Any rules in this context to be framed. And the rules was ultimately framed by the UGC in the year 2010. Now, they cannot say, my lord, we have adopted these when the UGC rules were not there. When you have adopted the scheme, and the scheme itself says, it will be subject to any rules to be framed. And that was ultimately framed. So my humble submission, my lord, this is a right.
Where is the rules from the
I'm just coming, Your Lordship. Lordship will kindly come to that appendix.
Let's not digress. Let's hear him first. Again, unnecessarily, we want to prolong the case.
Yes. Let him complete, Your Lordship.
5 minutes.
I don't know. Let him complete.
But today we're very busy, because the new CG is coming in the afternoon. Then we have other meetings also. That's why I said Friday is always a very dicey. We can't give enough time. Yesterday I could have heard the whole day, actually.
But he is a problem. Second half he cannot be there. If he is a part out also, he is busy in some of the courts. This has been going on, my lord, for last one.
Some people put their family before their work. That's important also. You do one thing then. You complete the arguments.
My Lord, more or less, but my Lord, of course, few more things I would like to go into, my Lord.
You give your submissions on by bullet points.
Written points.
Okay, I'll give you one more date. In all fairness, because I've given Mr. Sen enough. Also,
but
he's
whatever
argued.
reply necessary only.
Yes. Okay. Just one more date. We'll fix it on Tuesday.
I have noted down.
My Lord.
Tuesday, fix it on 12th. Okay.
12th, my Lord.
You heard. I want to finish. If it doesn't be satisfied, I'll file bullet points. You file a bullet point.
Yes.
But for you, nothing else to say, Mr. Sen.
Anything, because he has now come up with the notes. He has not read the relevant part. This disbursement again say.
Okay. I get it. Yes.
I'm not denying that.
Mr. Senso is very tenacious. He won't let you go that easily. He won't let you go that easily also.
But only thing, Your Lordship, I don't know, my Lord, it's happened repeatedly. Even if Your Lordship list it on 12, let him make available. Otherwise, my Lord, he'll be in some other courts, some personal problem. That should not happen.
My respectful submission, my Lord, if I fail to appear, my Lord, normally because I am in some other court, my Lord. That is not, because, my Lord, on the first day when it was...
No, that I do not agree. I do not want to make any...
My Lord...
But you're expert. That's all.
My Lord, on the last occasion,
my Lord, I should not say,
my Lord.
Lordship is fully aware what is happening in this case.
Yes. On the last occasion, my Lord.
I've not heard a case
I was
so many
before.
days.
But my Lord,
and on a point which is so innocuous.
Lordship, nowadays this is not being followed. In our time, my Lord, recollect, any part-heard matter, then we'll see if there are two part-heard matter, where is the senior most court?
Yeah.
We'll give first preference to the senior most court, then we'll go to the other. Nowadays, nobody, my Lord, it's a very unfortunate part. Keeping a court waiting.
See, another thing now, Mr. which I noticed in the petitions that are filed, suppose even application for condemnation, I mean, the basics are not there.
Yeah, man, it's very unfortunate.
The basics, I mean, you read, the basics are not there. That, how to explain condemnation, the calculation, the basics are not there. And all this, the basics are not there. I mean, in the entire, how it's, how it's styled and how it's written. The petitions, you read some, at least you are not sitting this side. If you read some petitions, that come for me, you'll cry. You can't make out what's the cause of action till you reach the prayer also. So that is the thing. And we were very particular at that time how we draft is not so. I'm used to certain style. So when coming this side, sometimes when looking at this thing, you feel like just throwing that file. You can't make out head or tail of what that petition is trying to say. Impossible prayers made. There's no what do you call it, a thorough study or how you draft second appeal, how you draft self-revision. That totally. It's like that. At least what is second revision, what's the second appeal, what's the first appeal. It's totally different how you draft it and how Anyway, what to say?
You can change.
Everything is come instant. It's all online. Everything's online. Everything's instant.
And particularly about this part-heard matters. You remember going to chamber, keep aside other thing. First to attend part-heard matter, then other things. But nowadays, part-heard matter lies somewhere else. Should not happen.
Exactly. Yes, 12.
Oblige.